230.
For orders matter, list number 1, serial number 10, Tom Shekaraya RP for petitioner.
A memo is filed seeking to withdraw the writ petition with the liberty to challenge the compromise decree made in OS number 766 of 2021, dated 14/8/2021. Accordingly, the writ petition is dismissed as withdrawn, and the petitioner is at liberty to challenge the compromise decree in accordance with law.
Serial number 11.
You that there is a letter.
Yes.
It is a letter is addressed dated 25/7/2026. This also letter is dated 25/7/2026. Tell the registrar. 25/7/2026. Seeking extension of time of another 60 days. The they don't even write the letters when the petition is disposed of. Nothing. This court on 15/4/2026 has disposed of the matter, directing the court to dispose of the pending applications, to dispose of the case within a limit of 60 days, and as per the special notification dated 29/5/2025, the matter was transferred to the 8th ACGM court. Hence, the learned judge requests 60 days time to dispose of the matter. Accordingly, 60 days time is granted, and it is made clear that no further time will be granted. Yes.
Serial number 12, Sri Vidya M.
The writ petition is filed seeking the following prayer. This court has called for a report from the concerned court how much time it requires to dispose of the matter. As per the report, it is stated that they require 3 to 6 months time for disposing of the miscellaneous petition number 10 of 2023. Accordingly, the writ petition disposed of, directing the court to dispose of the matter within a period of 6 months from the date of receipt of the copy of the order. Yes.
Serial number 13, Angad Kanwar.
The petition is filed seeking the following prayer. This court has called for a report from the concerned judge, and the report is placed stating that the trial in this case has been completed on 13/7/2026. The case was listed for final arguments on main suit by both sides on 19/8/2026. On that day, counsel for the plaintiff sought adjournment for a week on the ground that the senior being infected with malaria fever. For the said reason, case was adjourned finally for arguments of both sides by 28/8/2026. Presently, the case is listed on 28/8/2026 for final arguments of both sides on the main suit. Considering the report of the learned judge, the writ petition is disposed of, directing the matter to be disposed of within 2 months from the date of receipt of the copy of the order.
Parted cell number 14, Parashuram KR. Parashuram KR for petitioner.
I represent the
Kinavish.
petitioner in 14.1 minutes.
Appear for petitioner, my lord.
For respondent.
There are two cases. One case is filed by the bank, challenging the order of the magistrate. One case is filed by the
What is impugned in this? WP 119990 of 2024.
double one. That is what in the 119990.
Hmm.
Bank has challenged the order of the magistrate, my lord.
Hmm.
My lord, in this case, what has happened is, can you see the prayer, my lord? Page number 15, my lord.
Quash the orders dated 28/12/2011. How can you question a 28/12/2011 order?
No, subsequently, what happened, my lord? 28/12/2011 was passed. It was without the knowledge of the bank. It has been passed. It is the internal order passed by the magistrate, my lord. And 2/12/2023, subsequent to the DRAT order, we filed a memo stating that there was a delay in execution of the order. Hence, commissioner may be appointed. That was rejected.
Come to the order. Where are the orders? All the three orders.
Turn to page number 21, my lord. I have perused the order passed by the court in the revision 5/20/2011. So the honorable court was pleased to hold that the chief judicial magistrate is not competent to entertain the petition under section 14 like that. He has recalled his own order. Earlier order was passed in page number 20, my lord. On 8/3/2002.
So, under section 14,
Yes, my lord.
what are the powers of the judge?
We are seeking the permission to take possession of the property. He has to give permission.
And what are all this?
That is what, my lord. What happened is, my lord, in 2006, the bank has issued a sale certificate, my lord. Subsequently, the borrowers challenged the sale notice in the DRT 133 of 2006. It came to be dismissed in 2011. In 2009, what happened? The OA filed with the bank was partially allowed. In the sense, the guarantor was discharged from the liability. So, bank could not able to give the possession of the property to the auction purchaser. Subsequently, after challenging the bank has challenged that order in DRAT Chennai. Chennai in 2010 they have filed it. It was disposed of in 2023. In 2020, after disposal of the OA, the pending sitting aside the order of the DRT, in 2023, bank moved a memo before the magistrate stating that this is what has happened. Kindly allow us to take the possession of the property. That memo was rejected.
Stating that?
Stating that there is no averment in the memo. The reasons for delay.
Delay of what?
Delay in the sense for taking possession of the property. Subsequently, the bank filed one more memo along with the affidavit narrating all the sequence of events. That was also rejected, my lord. That is why I challenged all the three orders of the magistrate, my lord. You have to hand over the position of the property to the auction purchaser, my lord, and the borrower has challenged the appeal, that was dismissed. He went to DRIT Chennai, that was also dismissed, my lord.
Where is it? There are three orders. Where is which one is the latest order?
That was yesterday I have shared, that page was missing. Yesterday I have shared.
Your copies of photo.
Yes. Yes.
May your lordship. It is not in dispute that the scheduled property, though it is an agricultural land, was put for auction, which I challenge. But the Honorable DRT Bangalore in ASA 133, page number 71, dismissed on 12th January 2011. It is not in dispute. Subsequently, the respondent bank filed a OA wherein they are claiming all the liabilities, including the borrower who are respondent here. But DRT passed the order stating that whereas OA against fourth defendant and his property is dismissed. I am permitted to take your lordship to DRT order which they have not submitted.
No, I have submitted.
The DRT order they have submitted, but not DRT order.
What is
That
the
order also
present
I submitted,
order?
my lord.
Yes.
What is the present stage? After that, what happened?
Against this order, the bank preferred appeal before
Yes.
DRT. DRT set aside the order passed by the DRT in so far as discharging the liability of the fourth dependent, who is the petitioner respondent herein. In the meantime, the DRT order also has categorically has mentioned stating that the order passed by the page number 66 of their petition, my lord, page number 66, 64, 66, operative portion, para number 18. Hope your lordship got it. In view of the above, the appeal is allowed. Impugn order dated 34/2/9 is modified as prayed for. Tribunal below is to issue modified recovery certificate in accordance with law. So in the meantime, based on the OA, which was allowed partially, the recovery certificate has been issued by setting aside the entire proceedings, whatever. So two controversial views were taken by DRT, same presiding officer, the other presiding officer. One says in OA, discharge, dismiss the petition, their defendant number 4, who is the borrower, respondent here. And one more presiding officer says the measures invoked by the bank is in order.
Have you questioned any of the proceedings?
Now DRT has passed the order.
No, you are not a petitioner in any of the writ petitions.
Yes, I am the petitioner.
In which matter?
Here, DRT also appeared in the one.
No, I'm saying before this court. You have not questioned any proceedings before.
No,
this
we are appearing by filing wakalatnama.
No, please.
Yes, my lord.
You have not understood what my question is.
Please, my lord.
I said, we are not going to go into any or legality or otherwise of any of the orders passed by any of the courts. Particularly, you cannot raise it for the reason, already all of them have attained finality. Now, as per the final orders passed by the tribunal, this property is under the in respect of that property. Now we are only on the issue why the magistrate has passed this order. We will not go into whether two benches have taken a contra stand or which is correct, which is not correct. That is what I'm saying.
Yes.
Yes,
My submission is under section 14, it is surpassing measures.
yes,
Wherein the auction purchaser has already approached the civil court for granting of bare injunctions. That fact is not forthcoming because on the earlier occasion, in that 1535 petition, Sri V.B. Ravi Shankar, the learned counsel for the petitioner, submit that notice to the respondent number 2 to 5 dispense with, because these respondents are unsuccessful even in the proceedings before the DRAT. Here, the what reference he has made, respondent number 2 to 5, is the other legal heirs of the late Krishnappa. We have nothing to do with that in respondent DRAT. They did not appear, whereas we have appeared. They have not served any notice to us. How it can be dispensed? For that, kindly see their own petition, who are all parties at page number 52, wherein we are the parties, legal heirs of Krishnappa and Anjanappa, represent DRAT, but this in this petition 15355, they have approached the civil court, wherein for bare injunction they wanted to take the order from the original civil court. They did not appear. Then it was dismissed for non-prosecution. That entire set I am producing, my lord. I am permitted to submit.
take that. But how are we concerned with all that? I'm not able to
Then,
understand.
no, only one submission is the magistrate court order cannot be passed on the dead persons. It is executive ministerial. But those their banks are aware in 2011 order, when they are filing this application, the legal heirs of so and so expired, those are to be brought on record. Then only the executive order can be passed. That is my submission.
Then we'll ask the court to do it.
Please, my lord. One more thing, my lord. One more submission. I may permit to,
Take that. Yes.
and the details of all the legal heirs also I submitted.
And it's just a formality because there is, these people have no say before the section 14.
No, that division with that we are challenging the order passed by DRAT. In the meantime, so many people expired, so because very difficult to, we are.
I'll pass an order
Please.
directing the court to pass orders on section 14 and you take
Please.
necessary amendment to the,
Please, my lord, there's a, that's a,
Amended, my lord.
Huh?
Already they have got on record.
no.
Kindly see, yes, my lord.
where is that?
Kindly see the first page of the cross title, my lord.
Where?
Where yesterday I produced that.
Uh-huh.
my lord.
No, where is the copy?
First page itself.
Pavan Putra, P.
Krishnappa
B.
died.
Krishnappa died,
When
represented by H.K. Anjappa, Muniyamma, Mariamma, Sundaramma.
no notice will be issued to the.
It is not required.
No, Muniyamma is expired and Sundarama is also expired. That is the reason, death certificate I am producing it.
When they died,
Yeah, 11/12/2020, 26/10/2012.
you can tell when Muniyamma died.
I may permit, I will assist the court with my copy. Our copy code.
Yes. 19,
11/12/2020, Muniyamma died.
where do you get that? It says 19/11/2009.
No, no.
Marana Dinamsa.
19, no, there is a Krishnappa, above Krishnappa.
Ah.
Krishnappa and Bhairappa and Sunandamma,
No, Krishnappa sellers are already brought. That is
Ananda-
not relevant now.
that Muniyamma. And this Pradeep Kumar, they have brought Muniyamma, that Sunandamma also expired.
No. If you tell me without looking into all this,
Yes,
you
ma'am.
can assist the court.
Okay.
H.K. Anjappa is alive or not?
Who, Lordship?
H.K. Anjanappa,
They expired. Anjanappa is expired.
when he expired.
No, my lord, he is alive.
No, Allah.
Expired.
Huh?
2015, my lord.
Ah.
22/12/2015.
22/12.
2015.
Who are his legal heirs?
We do not know. me.
All the things I have brought.
Where is that?
Legal estimate. I got the leader.
Allah, family tree.
Anjanappa Beda.
Family tree, my lord.
But in the last, third, family tree of late Anjanappa, died on 22/12/2015.
Increase the fan speed. Fan speed increase. These are all the death certificates you have filed.
Yes, they are the legal heirs of Anjanappa as well as Krishnappa. My submission is, unless the recovery certificate is modified by the debt recovery tribunal, as per the order passed by the DRAT, which is in page number 66, surpass is only a measure. When the respondent herein, who is the defendant number 4, when his liability and property is being discharged, even property in accordance that is discharged, dismissed, sorry, with the word they have used, dismissed, then unless it is set aside or modified or recovery certificate is modified to that extent, the presiding officer, he is a quasi-judicial. The authorized officer is below the rank.
What else objections can anybody have? Once during the lifetime of so and so, when an order is passed, what is the objection the legal heirs can have? And can that be considered?
No, in the 2011, now they are executing it by bringing the LRs on record. All the LRs have to be brought on record. One stand I am taking it.
That is just a formality.
Yeah, that is formality. That another stand, unless the recovery set,
An order that is passed long back, even till it is now not executed. Now, if it is not expeditiously done, it is a pure abuse of process. And I'll direct the learned judge to complete it as within a matter of 15 days, you should complete everything. Please.
no, Your Lordship, the one more submission, when they,
That wherever submissions you have to take, you please state.
no, here, WP
Only
number,
concern-
WP number 15355 is there, na? There,
Now let me pass orders.
there,
in
no,
the-
sir, no.
That is a writ of mandamus.
No notice has been served on us.
I am not
My lord, I've
passing
sought
any
for
order.
dispensation, my lord.
Please wait.
My apologies.
I am passing orders on 11990. When I come to that, you can make your submission. Please come. The present writ petition is filed, seeking the following prayer. Please write the prayer. Petitioner is a public sector bank. It is the facts of the case are that one Sri Krishnappa had created equitable mortgage for an extent of 1 acre 18 guntas as security for the credit facility obtained by Mrs. Pavan Putra on 18/2/2002. Thereafter, when the account has become an NPA, the proceedings were initiated under the Surface Act and the property was put to auction. It was purchased by the successful bidder for an amount of rupees 1 crore, 5 lakhs. Sale certificate was issued on 9/6/2006.
19-1,
Hmm?
19/1/2006. 19.
I'm looking at page 10 of your papers.
In the synopsis it is.
In that you said 9/6/2006. Para number 4 of the writ petition. 9/6/2006. In the meantime, the petitioner bank has filed OA number 365/2004 that was disposed of on 30/4/2009. And the OA, in the said OA, liability against the guarantor, Krishnappa, was discharged. Pursuant thereto, the petitioner, the bank has challenged the said order before the appellate tribunal, before the DRAT at Chennai, in RA number 83 of 2010 on 19/3/2010. The Honorable Court was pleased to set aside the order passed by the DRT in OA number 365/2004 on 29/9/2003. The auction purchaser has filed WP number 439 of 2007, seeking a direction to the bank to initiate proceedings against Krishnappa under Rule 99 of the Security Enforcement Rules 2002. The said petition was disposed of on 14/3/2008 with a direction to the petitioner bank to put the auction purchaser in possession of the property. The Guarantor has challenged the surface proceedings initiated by the bank in ASA number 133 of 2006. The said appeal was dismissed with cause on 12th January 2011. Thereafter, the petitioner has filed the application before the Chief Judicial Magistrate, Bangalore, under Section 14 of the Surface Act for taking physical possession of the property mortgaged by the guarantor in criminal miscellaneous number 36 of 2011. The said application came to be allowed on 30/4/2011. Subsequently, the court posted the said case for compliance of the order on 14/6/2011, 19/9/2011, 28/2/2011, and on 28/2/2011. The court, without any reason, has passed an order holding that the Chief Judicial Magistrate has not been conferred with the point of jurisdiction under Section 14 of the Surface Act, and the court is functus officio to entertain the petition. In view of the orders passed by DRT dismissing the claim of the bank against the mortgager, the bank could not execute the order passed by the CJM, and I was waiting for the outcome of the proceedings in the appeal filed before the Honorable DRAT Chennai. The petitioner was entitled to take possession of the property after the order passed by the DRAT in RA number 83 of 2010, dated 29/9/2023. And the DRAT allowed the said appeal by setting aside the order of the DRT. Then again, the petitioner approached the court by filing a memo on 2/12/2023 in the said criminal miscellaneous number 36 of 2011, seeking for appointment of the commissioner for taking physical possession of the property. But the same was rejected, but the court has rejected the memo. He has filed another memo on 16/1/2024, explaining the reasons for approaching the lineage judge. Without considering any of the aspect, has rejected the said memo by an order dated 18/1/2024, which made the petitioner to come before this court. Land counsel appearing for the petitioner submits that when already the proceedings with as earlier ordered in the year 2011 could not be taken to a logical conclusion in view of the pending proceedings, and when all the proceedings have attained finality in the year 2023, when the petitioner has approached the court ought to have passed orders. Instead of that, all the application, the memos that are filed are rejected by the court. The learned counsel appearing on behalf of the respondents submits that the it is stated that the Muniamma, who is the fourth respondent before this court, died on 11/12/2020, and she is survived by the Krishnappa has three daughters, and two sons. And daughter Muniamma, who is the fourth respondent in this case, died on 11/12/2020. Sundaramma, who is sixth respondent here and died on 26/10/2012. Bhairappa, He was not made a party. He was not made party
Was
to.
not made.
HK Bhairappa is the son and HK Anjanappa is another son. They are not made parties.
No, Anjanappa has been made as party.
In this writ petition is not,
No, here in there, see, Mr. They have made as Anjanappa as a party. In page number 18,
then why writ petition some other cause title? Where is
Anjanappa is there.
Anjanappa?
18, Krishnamba dead, HK Anjanappa is there. Anjanappa is also died on 22/12/2015. Page number 18.
No, we should carry the same cause title, isn't it?
Same concept,
HK Anjanappa died on 22/12/20.
It is mentioned, my lord. Anjanappa died dead.
No, Krishnappa dead or Kerala.
Represented by LRs.
LRs.
Anjanappa died and they have already brought the
LRs.
LRs R2 and R3. Manjula and HA Pratap Kumar.
The Pradeep Kumar died.
Then who is Bhairappa? Where is Bhairappa in this?
It was not available. Whatever the information given by the bank.
Yeah, Pradeep is the son of
Hmm.
Anjanappa.
The
Anjanappa.
the council has furnished the details of the family of the LRs of Bhairappa.
No, Anjanappa, madam. Anjanappa and Bhairappa both.
Are the details of Bhairappa and also Anjanappa, who died on 11/9/2010 and 22/12/2015. It is submitted that without bringing the LRs on record, the application under section 14 is not maintainable. Further, he is also submitted that the recovery certificate and other things should be amended by bringing all these people, by mentioning the names of all the legal representatives, unless and until that cannot be executed. He was also submitted on the merits of the matter with regard to how two benches of the PRT has passed orders that the property is an agriculture property that has been attached under the surface proceedings. Next, land council appearing for the respondent auction purchaser submits that though the auction was concluded in the year 2007,
Please, Madam.
2007 till now they could not enjoy the fruits of the said auction, and all this litigation is continuing from there. Next one, having heard the land council of the petitioner peruse the material on record. The powers of the magistrate under section 14 of the Surface Act are very limited. When an application is filed seeking assistance, seeking appointment of a commissioner to take possession of the property, the learned magistrate ought to have passed orders in accordance with law. When the proceedings are, when he has passed an order and when several proceedings are initiated by the parties, and at that point of time, question of taking possession would not arise in those circumstances. When in the year 2023, when the disputes in this regard have attained finality, when an application is filed, it's the duty of the magistrate to consider and grant appropriate orders under section 14. Now, by rejecting the memos in this manner, in a way, he is coming in the orders which are passed by the competent forums are not being executed, and a party who has paid the valuable consideration and purchase the property is not able to enjoy the property from almost a decade, more than a decade. The contention with regard to the legal heads concern, in the section 14 petition, they can always implead the LRs and the section 14 notice to the part respondents is not necessary. With regard to the other submission about the recovery certificate and all, in these proceedings, this court is not concerned with any of that. If the respondent has any remedy, a remedy in that regard, this court is not going into the said aspect, as the writ petition is only assigned questioning the order passed by the magistrate. In that view of the matter, the writ petition is disposed of directing by setting aside the so-and-so orders, and the magistrate is directed to pass appropriate orders in accordance with law within a period of 15 days from the date of receipt of the copy of the, within a period of 1 month from the date of receipt of the copy of the order, and the petitioner shall immediately carry out the necessary amendment to the cost item by bringing the LRs on record.
That's Annexure D, my lords. Is a representation which is dated 39/2020-23.
30,
39/2023.
page number.
35 minutes.
Here, I have not received the copy of the petition.
Because in this case, though you're, as he said that they are not necessary, it's between the bank and him. Bank has to consider. Your presence is not required to decide this. Even if it comes up on the first occasion, the court would have disposed it of. The writ
But
petition
here,
is fine.
they have filed OAS for non-prosecution got dismissed. There also they sought
Only
bare
seeking a
injunction.
direction to them. The writ petition is filed seeking the following prayer. It is submitted that the representation dated 39/2023 is given to the bank seeking a direction to the bank to deliver possession of the property. And it is a grievance of the petitioner that the said representation is not considered. Land counsel for the petitioner, land counsel for the bank submits that in view of the pending litigation, they could not deliver vacant possession of the property, and now they are taking steps and seeking taking steps under section 14 before the magistrate, and they'll consider they will take appropriate steps considering the representative submission of the land counsel for the respondent. The writ petition is disposed of, directing the bank to take appropriate steps as expeditiously as possible.
Cell number 15.
My lord, I appear for the respondent in this matter. This is the matter which had come yesterday, where your lordships had noticed, my lord, this gross abuse of process by them, and directed it to be listed at the top of the list, my lord. This,
Now, what is the order impugn? That is which page it is?
my lord, the impugn order, your lordship will kindly see, is, my lord, at page number 16,
Undalva.
15 and 16. Where, my lord, the trial court refused to grant any injunction on the basis, my lord, that there are proceedings that, my lord, you cannot ask for any interim relief when there is a surface or a proceeding under the Recovery of Debts Act. That was challenged before this honorable court. And without disclosing your lordship's order, which was passed, specifically, my lord, directing, dismissing all the reliefs that they had sought for, you have filed a suit asking practically for an injunction to restrain them from being evicted from the property.
Huh? Yes, argue. No password. Argue. Let him be. How many times the matter will be passed over? Yesterday the matter comes, you seek for adjournment, again today pass over? No. I will, if you want to argue, argue, or whatever the senior counsel argues, I hear it and pass orders.
The sales certificate in this case, my lord, was the year 2015. Sales certificate was challenged before this honorable court. This honorable court rejected, my lord, the challenge. After which, my lord, continuously they filed suits.
What is the suit for? What is the
Suit-
present suit for?
Yes, that is most interesting. Suit, my lord, is to at page 32. The prayer is at page 32.
Yes.
they first ask for declaration that he is the absolute owner, that he strikes off. Then please the next way, declare that the alleged registration of the property by defendant is null, void, and not binding on the plaintiff. The sales certificate which is registered is apparently null, void, and not binding. And then on that basis, grant permanent injunction restraining them from interfering with my possession.
No. With regard to that, this sales certificate, what are the earlier proceedings?
Yes, not. Your Lordship may kindly see my statement of objections. The sales certificate was challenged before the DRT, DRAT, and finally, my Lord, before this Honorable Court, the division bench at page number 47 considered this question. Page 50, my Lord, your Lordship will see.
17th November 2021.
20, yes, ma'am. 17 November 2021.
14083 of 2020.
Yes, ma'am.
And what is the order?
Order, my Lord, is Lordship will kindly see para 14 at page 58.
The petitioner had filed a petition for non-competition. So the petitioner not able to demonstrate that the sale has been held in violation of any the conduct of the petition has been contumacious. The petitions are restoring to success have stalled the proceeding for recovery of the public dues successfully. Therefore, we do not find any merit. What is questioned before the court?
In the there was a DRAT order.
The order dated 1/10/2020. Which is, what is that order?
That was challenging the sale, my Lord. They're challenging the sale which occurred in the year 2015, which is what ultimately the High Court upheld.
So 2015 sale was questioned before the DRT.
Then DRT rejected.
DRT held against.
Then Karnataka High Court.
Then when was the sale certificate issued?
2015 itself. It was registered then. The sales certificate was registered then. You are still challenging the same thing, not even now. Then they, my Lord, challenged it. They went and said registration is bad. They challenged it, my Lord, at page 60 before the Karnataka Appellate Tribunal, saying registration is not being done properly, stamp duty is not correct. That was then set aside. That order was set aside. Then, my Lord, they challenged it before this Honorable Court at page 74. Then, my Lord, after all of them fail, continuously one suit after the other is being filed, only to try and ensure that we are not in a position to take possession of the property, which is what your Lordships, my Lord, ultimately at page 175. My Lord examined this at page 175, my Lord. Your Lordships imposed costs on them for completely violating every order that there was there. Please see the prayer that was made in that case. After the sales certificate of 2015 at page 75, the prayer is at the top of page number 176. This writ petition is filed under 220 to direct the respondents to adhere to the laws of land in conducting the public auction to get a competitive price for the scheduled property and to quash Annexure D 23/1/2015, which is invalid, illegal, unlawful, not enforceable before law. That was the prayer. Then your Lordships, my Lord, after considering it, please see page 182.
Petition, counsel has come. Yes, take that.
As regards to the orders of WP 6820, the senior said that we have violated. No, it is not so. In both the cases, the
This 1 lakh rupees cost paid to the legal services.
No, appeal is pending. We have filed an appeal.
Stay is granted.
Yes. Appeal is pending.
No, stay is granted in the appeal. Stay of this order is granted.
Pending before the divisional bench.
No, there are 2 steps, isn't it? Filing of the appeal is not sufficient.
But after filing, there was office objection which we have compiled. They said they will.
That's what. So, as of now, there is no stay.
Yeah.
This order is passed on 14th October 2025. And there was a direction to deposit an amount of rupees 1 lakh to the Legal Services Authority.
Yeah.
That order is so far not stayed by the division bench.
We are waiting to get the remission from the divisional bench. We have made the prayer for that. That's the reason we are waiting. And as regards to another 36592, my Lord, all the
This order copy at page 175, send it to the Legal Services Authority. Yes.
All the respondents were not served the notices. And the IA we have filed has been missing, and the Honorable your Lordship said, okay, I'll take up the matter. It never came up, and the order was passed. The previously notices were to be served to the respondent number 3 and 4. All the respondents are not served the notices, and the order has been passed. And this order also has been challenged before the writ appeal in the this honorable High Court. Now, my lord, coming to the so as far as the allegations are concerned, that we have violated both this one is not correct. It is pending. We have filed the appeal. My lord, another thing, I would like to just take few minutes to explain. The account became NPA, an account of BMRCL MG Road Metro Station at no.
One minute, one.
No, I will just
No, no,
no, I just
1 minute, you can, I'll hear you. Now, you filed a sought for an injunction. Sought for an injunction. Court has issued suit summons. You came here. Court grants an interim order. Why should, how, now?
Yeah, I will explain that.
No.
I will explain the reason. When there was a DRAT and High Court stay was pending, this transaction has taken place. Wherein, my lord, if you look at on the page number 10, Annexure D, which I have given the memo now.
Court will consider.
No, I will take the
Trial court will consider.
No, my lord, 1 second, just listen
Yes.
to me, my lord, if you permit me. When there was a stay before the Honorable High Court here in 613, when they cancelled my OTS, after making a substantial amount, I sold 3 properties, which I have explained in this memo. After that, they are directed me to approach the DRAT. We approached the DRAT. DRAT said, whatever the balance amount on the OTS, you play. And we paid that as a no-lien account with the DRAT, we deposited. And DRAT gave a stay. During that stay, as well as High Court stay, that this transaction has taken place, this sale, which we have again challenged before DRT. And what has happened is, the valuation is not at all done in this case. Section 8 of Security Interest Enforcement Act is completely violated. They have not sought any the valuation report from anybody, 2 valuation under Section 8, which has been repeatedly asked. And the property, my lord, if you look at, I have produced a valuation report of 29 crores is sold at 7.52 because there is a vested interest in the bank by the manager. For 7.52, a property worth 5,000 land area, MG Road, Church Street itself will cost around 14 to 15 crores, and the building and other. And again, as regards to this one, Section 17 of Schedule 2 of Income Tax Act, the bank is not supposed to participate. I have produced the document, Annexure D, my lord. 26, the bank itself says nobody can participate. There is a paper advertisement in 2 cases, the same bank has released. So the bank participation cannot be done. What has happened is, this bank, in 38524, they gave an undertaking before this honorable court. My lord, I have produced that undertaking. On page 28. 28, the undertaking given by the bank. My lord, may I read it out? 28, Annexure E.
No,
Yes.
after certificate is
See,
upheld, my lord, is
will be
arguing
initiated.
sale certificate.
Learned counsel appearing for respondent bank submits that respondent bank would not take any precipitative action, including interfering with the possession of the property described in the schedule to writ petition till next date of hearing. It is also submitted by Sri V. Ravi Shankar, learned counsel, that proceedings initiated under Surface Act is not being proceeded, and a memo being filed before the DRT. Till date, my lord, I have produced the DRT orders on page 1. Till date, the memo is not filed. There is a DRT proceedings on page number 29. And also 30, till date, I produced the DRT proceedings also. In addition to this, the same bank has sent a letter to Reserve Bank of India, which is on Annexure G, page number 31, my lord. This is a very important letter, wherein the bank says they have withdrawn the third party entry forum 31 to decided to remove Mr. B.B. Ravi Shankar. This is again as a conflict of interest. I don't know what exactly has happened. The bank has given the letter to Reserve Bank of India, which has come to me, wherein This is because, and subsequently because of this, the memo is not filed before DRT telling that we will not take any action on it. Till date, the memo is recorded by the DRT. I have produced DRT also. In addition, my lord, at the time of granting the stay by the process took place. The recovery officer, the statement is made, there is no stay. And the recovery officer did not get into the details. He says the bank is telling us the DRT stay and the High Court is false. That is the recording of the order which I have produced. And meanwhile, when this 38524, this honorable court directed me to, again, when petition was filed to cancel the registration and to reclaim the property back in the name of this one, they directed me to approach the DRT. I approached the DRT, which is pending, and DRT has passed an order, my lord, page 29 is very important. Annexure F. Annexure F, memo then.
Oh, you're referring to so many which I'm not able to even see.
The reason is
This-
because the issue should have been only on 9154.
I am saying that I'm not able to see the paper which you are referring. You say 29, I don't find it. That's what I'm saying. You're not listening.
It's in memo, ma'am. It's in memo.
That's what you have to clarify that. Otherwise, what is the use in referring to the papers which I'm not able to see?
I'm extremely sorry.
Is it the memo?
Just now I gave.
Yes.
Page 29, annexure F.
Yes.
And on page 30, my lord,
Yes.
the DRT directed me to approach the appropriate authority in the matter as far as the registration is concerned. Accordingly, this was it. Meanwhile, on page, last page, my lord, 33 and 34. In 34, the amount deposited in no-lien account has been forfeited or whatever exactly has happened, no news. This honorable court directed the respondent bank not to disturb that no-lien account amount to the tune of 1 crore 5 lakhs paid before the DRT not to be disturbed. And they are violated. And the DRT, the matter came up before DRT on 20th May, 34 page number, my lord.
Yes.
The matter has been taken up at the proceedings are pending before the recovery officer and learned counsel for the petitioner submit that during the pendency of the OA and proceedings before the Honorable High Court of Karnataka as well as Honorable DRT, the bank had appropriated the substantial amount despite the direction to keep the same in the loaning account. Having heard the respective counsel, this tribunal is of the view that since the matter is pending, the matter before the recovery officer, it is for the petitioner to point out all these facts before the recovery officer, and this tribunal finds no reason why recovery officer should not go into all these details before proceeding officer for hearing on 24/8. Yesterday was the hearing was there. Subsequently, it has been postponed. Now, my submission is the registration itself is wrong because the stay order was pending before DRT itself. From 2011, when they registered in 2015, when the stay is pending, they have registered this property. Undervaluing the valuation. Anybody can ask, anybody on the road will tell you what is the value of this property on the Church Street. And we got into this NPA not because of any other. We have been running the business from 1990. We never had a problem. The bank approached us to expand the business. We expanded. Then BMRCL is adjacent to my building. The whole wall was being collapsed. We have filed a suit. We approached this honorable court and they directed me to file a civil suit to get the damages, which is pending. Well, this is not an intentional not to pay the bank or anything of the public money.
Yes.
Now, another thing is, in this case, since the DRT said that this matter of Sale registration or another thing is a matter of civil courts, not under the DRT. Yes, we approached the civil court. Civil court, what they did is, it comes under surface. I said, this is not under surface. I am approaching under DRT. Surface, yes, section 34 of Surface Act is not allowing. I am coming under RDD there. I gave him a lot of citation of Honorable Supreme Court in Hong Kong Bank and Union Bank itself. And they were in civil courts have got a right to interfere in this matter. Accordingly, I approached the civil court. The civil court, without even RDD is not applicable to civil court. Then I approached this court in this WP 19154, where I thought, when there is a provision under RDD, because RDD doesn't pass the civil court, it's up to the borrower.
So where is all that recorded in the interim order?
It is there.
Where is the affidavit filed?
This is filed.
Production of certified copy of B is dispensed with.
33/2000.
Parties are directed to maintain status quo.
Yeah. That is
Now, when we are saying that, when the law demands that whenever an injunction is granted, there has to be, you have to satisfy the court with what are the ingredients for grant of an injunction. And all that be recorded. Basing on that, an injunction or a status quo interim order has to be granted. I will ask the trial court to decide it. And this order of status quo cannot be granted like this manner.
No, I have compiled the orders, whatever the.
If the court has issued suit summons, we should tell the court to hear the matter. Not granting interim order here by prejudging everything is not correct. That is not the course available to the High Court.
No,
Because it requires hearing, it requires finding on the fact, on the aspects. Please come.
No, my lord,
I will ask the court to decide it. We can't do like
No,
this.
my lord, here, DRT also has mentioned.
Let all reasons come on the record. Let the court decide it. We can't grant orders like this. The writ petition is filed.
Status quo is because the recovery officer, even while the.
Court will decide.
No,
Court
no,
will decide.
no,
This is.
my submission, my lord. When there is a.
This is contrary to the settled law. This is
No.
contrary to the judgments of the
My lord,
Supreme Court.
because the registration can take place and there is a stay before this honorable court and a DRT.
What do you, no, please wait. You wanted the court to consider your application for injunction. Court has not considered and
No,
please listen to the court. The court has not granted and issued suit summons. You have come here. You have come
My
here.
submission.
So let the court decide it. We will not prejudge the
My
things.
prayer was to cancel the sale registration because of in violation of section 31 of specific.
That will be
Relief Act.
considered by the trial court. It has to consider.
No, till such time I asked for status.
I will
quo.
ask the court. I will ask the court to do it. Not this court will grant.
No, because.
By giving an opportunity to the respondents, let both the parties be heard and then pass an order.
Because this is a lot of ramification is involved wherein the honorable, this court orders also have been violated.
That will
By
be
the
clear.
recovery officer as well as the bank. That's the reason.
The present writ petition is filed. Questioning an order dated 11/3/2026, whereby the court has issued suit summons to the defendants and directed the matter to be called on 15/4/2026. Then the petitioner has approached this court. A coordinate bench of this court has passed an order dated 2/4/2026. Extract that order. That order has been extended from time to time. The vacate petition is filed with the respondent bank. When counsel for the petitioner submits that
My lord, the petition is filed by me, not the bank.
vacate petition, I said.
Vacating,
When counsel appearing for the petitioner submits that, when an application is filed, bringing it to the notice of the court that there are violations, that the sale itself is conducted, that the sale certificate is issued when there are orders by the DRT, DRAT, and
High Court.
Leonard and the High Court, and the Learned Counsel submits that there are several illegalities, irregularities taken place right from the conducting of auction, fixing the sale price, and every aspect is vitiated. In those circumstances, he has approached the trial court by filing the suit, and the court is without granting the ad interim injunction has sought, has issued the suit summons. It is submitted that he has also referred to several proceedings that are pending before the the proceedings that are pending before the DRT and orders passed by the DRT. It is submitted that considering all these aspects, the coordinate bench of this court has granted an order of status quo. Hence, that order of status quo cannot be vacated, and there may be a direction to the trial court to pass appropriate orders. Learned Senior Counsel representing the bank submits that the auction was conducted in the year 2015. Sale certificate was issued in 2015. The petition has gone to DRT, DRET, and to this court. And a division bench of this court had dismissed the writ petition, that is by order dated 17th November 2021 in WP number 14083 of 2020. It is submitted that, in fact, when the earlier writ petition is filed before this court, where is that order?
Page 175, my lord. Your lordship's order. (14-10-25) order.
When WP number 6820 of 2025 is filed, questioning seeking a direction to the respondents to adhere to the law of the land in conducting the public auction, to get a competitive price for the scheduled property, and to quash the sale certificate issued to the single bidder, that came to be dismissed by order dated 14th October 2025, wherein this court has observed that looking at the manner in which the petitioner has approached the court with successive petition is nothing but a pure abuse of process of law. Access to justice does not include a right to misuse the justice delivery system. It has been consistently held that litigation filed with an ulterior motive deserves to be dismissed with costs. Accordingly, the writ petition is dismissed with costs of ₹1 lakh payable to the High Court Legal Services Authority. It is submitted by the Learned Senior Counsel.
One more submission. DRT has directed to approach the civil court. DRT also has said unless the amount is deposited and the loan account, whatever the balance amount, the ODS still as on date, as per the DRT, I am entitled to. And another very important, my lord, which I have mentioned in my memo, the mortgage documents as on today is impounded under section 33 and 34 of Karnataka Stamp Act. And that is why the mortgage document cannot be registered. There is a fraud played by the bank. They never informed that these documents, which is mortgage, has been impounded because they did not pay the stamp duty collected from the and they have not registered either central registry or by ROC or under Karnataka Stamp Act 33 section 34.
It is submitted.
I have produced the order of the deputy commissioner at the district
Senior Counsel. It is submitted with the Senior Counsel.
Will be taken on record that also.
All that not necessary in this case.
No, my lord, this is very important.
Learned Counsel.
My lord, this is very important criteria for the law. When the documents, mortgage documents.
Am I deciding your suit?
No.
Am I deciding your suit?
No, not.
Am I deciding your interlocutory application?
In the earlier
I am saying that I am not going to go into any of the merits of the matter. That will be decided by the trial court. The Senior Counsel.
My lord, my humble submission is, with the document
one after the other, several writ petitions are filed. And now, by virtue of this, then in this court, a status quo order is passed. In response, Learned Counsel for the petition submits that several irregularities have taken place. He has stated about the document that is being impounded, the mortgage documents being impounded, and several contentions are raised by the Learned Counsel for the petitioner. This court is not inclined to go into any of the aspects, as this court is of the view that when the suit summons are issued by the court without considering an application filed seeking ad interim injunction, the only course available to the High Court is to direct the court to consider the application. If the injunction application for any reasons if this court has to consider, the court has to pass the court has to record the reasons, as it mandates that when an injunction is sought, the three ingredients of prima facie case, balance of convenience, irreparable loss has to be discussed, has to be a finding on that. And without that, either it is the high court or the trial court cannot grant injunction. Then coming to the facts of the case, considering the what is impugned before this court is only the suit summons that are issued. In fact, the suit summons, the court has directed that the suit summons are issued and the matter to be listed on 15/4/2026. By this time, the court would have heard the matter and would have passed appropriate orders. And and the merit petition is pending before the court. Hence, this court is of the view that if the trial court is directed to consider the application of the petitioner, that would serve the purpose. Accordingly, this court is passing the following order. The writ petition is disposed of, directing the trial court to consider the application filed by the petitioner seeking ad interim injunction within a period of 15 days from the date of receipt of the copy of the order.
My lord, one small submission.
Lord, you may say interim order is dissolved, Lord, because they will come and argue that it is still there.
Actually, this is what documents of the property is impounded by the government. How can those documents have been registered? Which is a major question.
All the questions are left open to the parties to submit before
This
the.
question also has been raised in 682 and WP when I filed
Yes,
before.
yes, please.
my lordship.
16,
Yes,
preliminary
please.
hearing.
Great.
Tyagaraja M for petitioner.
Yes,
Wait.
Of the petitioners, which time may be granted to produce some more documents which are
issue a writ of mandamus to quash the impugned order. What is this writ of mandamus to quash the impugned order?
the improved order. The order is at page number 43. There are other two.
4/11/2025 order, you want some more time.
There are other litigations between the same parties and
No,
the same
you
property.
argue on the merits of the matter. We will not keep the writ petitions for some, for extraneous reasons.
But
Come to the order impugned. Where is it?
The improved order is at page number 43. The idea for protection, seeking jurisdiction from jurisdiction police.
Where is the injunction granted to you?
But there are two litigations which is referred to by the parties in the LDA. At the
No,
page
no.
23.
You can ask for protection provided there is an injunction for implementation of the orders. Just like that, why will the civil court direct the police to give protection to your property?
But, the respondents are seeking police protection against me because these are bearing Indian suit.
Injunction is granted.
Injunction is granted.
Then
There is another two suits pending between the same parties and the same property. That's not been that's been stated by the respondents in the LDA itself.
no.
That is pending for
When an
consideration.
injunction is granted against you,
Yes, ma'am.
have you questioned it?
There is question with regard to possession and
Have you questioned that injunction order?
I need to take instructions to that.
No, it's already high time that you should have taken by this time. And we will not keep this writ petition pending.
2 days maybe. granted.
No 2 days.
I will place
This
all
is
the-
matter on Saturday on the top of the list. Yes,
Number
17.
17. Prasad BS for petitioner.
Petition.
Yes. Where is the order?
Page number 23. Application for among the documents and additional list of witness that has been dismissed.
Suit is of the year 2011. What is the present stage?
Present stage with the not defendant's evidence. Defendant evidence. Because earlier, my lord, they filed a suit and withdraw, and all the document I have produced before the on that suit. Later,
What are you doing in a 2011 suit till now?
Because earlier, my lord, they obtained a stay order now from the Honorable High Court, and earlier, my lord, they filed a suit, and when the matter reaches the finality, they withdraw the suit, and once again, the brother filed a suit, this suit, and I produced the document, produced the document before the mortgage document, bill, original bill, to
tallying and the signature of the will has to compare, my lord, only for that purpose.
What is the suit for? What is the suit
Suit
for?
for partition. They are saying that, my lord, I am not at all concerned about it with the family. And my contention, my lord, defendant number 22, 23 is adopted son and adopted sisters of one of the family member. And all documents is in documents, education documents also in our favor. And my mother and adopted father and mother, my lord, executed a will. That will I mortgage and obtain the loan. So more than 48 lakh loan is there. I can't at a time reimburse that entire loan. That is the reason, my lord, that will has to be produced by the bank to summon that document and only limited prayer. Or otherwise, my lord, my entire claim will go. LC page number 26.
Why should the court call you? That's for you.
But because of
You
that,
have mortgage.
yes, madam, mortgage because of I don't know.
Then why will the court ask them to produce
I
it?
don't know they will file a suit for file a suit for partition. Before that only I obtained a loan. And at the time of obtaining the loan, all original document there.
So whatever documents you want, which are ought to have been produced by you, the court will call for it.
No, not my submission not like that. Original will, my lord, is not available. Original will, my lord,
Make a request to the bank.
Pardon?
You make a request to the bank.
Request to the bank, my lord, they will say that, my lord, we have to reimburse entire amount. Reimburse entire amount. Then only thing, my lord, is not the bank.
Notice to the respondents and summons. Yes, take.
The stay, my lord,
Sir.
otherwise they will post for the argument and my entire claim will go. Limited period.
2011, you keep quiet and now you realize that.
One more petition also pending.
Yes,
Petition number 2.906.
post along with that. List or if the memo is filed, list the matter on 9th of September. Yes,
Cell number 8.
9th of September.
Cell number 18. Vinay
Appear.
CM.
Appear for the
Yes.
petitioner, Your Lordship.
Yes.
In this matter, Your Lordship, I sought for the
1 minute.
Spot number 6 to 23, my lord, is not necessary.
Memo is filed seeking dispensation of notice to 6 to 23 dispensation. Notice to the councils of respondent 1 to 6. Yes.
Your Lordship, suit is for partition has been decreed. Against the same said decree, I prefer the RA, Your Lordship, 40 of 2024. In the pendency of the RA, there was a delay, Your Lordship. For that reasons, notice has been issued. Now the plaintiffs, they file a FDP proceedings. In FDP proceedings, Your Lordship, appointment of commissioner has been application has been. I filed the objection stating that RA is a very preliminary decree has been challenged in RA. The same is pending. In spite of that, without considering the same, the trial court appoint the commissioner.
Why should the court consider?
Your Lordship,
Why
because
should the court consider?
since I question the very preliminary decree, Your Lordship, that is the granted
Then
land which is.
whenever you get your delay condoned, whenever you can get an opportunity that you argue, because
Your
the
Lordship.
FDP court, unless and until there is stay, it has to go on.
Your Lordship, my second prayer is in this writ petition, I sought for that let him expeditiously RA at least because
Agreed, the present writ petition is filed questioning an order dated, order passed in I number 2, under orders 26 rule 10B, reduced section 151 CPC, in FDP number 24 of 2022, by the additional civil judge Tiptur, dated July 31/7/2025. The petitioner herein is a defendant in the suit. The suit was decreed and against that he has filed the RA number 17 of 2017.
40 of 2020,
7.
40 of 2024.
It says 72 in RA number 17 of 2017. That's what the order reads.
Your Lordship, that is the suit against that.
No, in the order, it is number, it is shown as RA number 17 of 2017. I'm looking at the order.
Yeah, that is,
He has filed RA number 40 of 2024 before the senior civil judge and JMS Tiptur. And there are no orders in the said RA. Hence, he has sought for, hence he filed an application. Filed his objection that till the said RA is decided, the further proceedings in the FDP court shall not be taken up. That the court had refused to take the said objections on record and allowed the application. And accordingly, surveyor is appointed and appointed. Then comes for the petitioner submits that pending RA, if the final decree proceedings will go, the final proceedings or final decree proceedings are continued, it would cause a lot of hardship to the petitioner, and the court ought to have stayed the further proceedings. Next, for having other counsel for the petitioner, per the material on record. When there is no stay by the court, so stalling the final decree proceedings, there is no impediment for the final decree court to continue with the proceedings. The petitioner is entitled for an interim order in the RA, and as RA, and if at all the petitioner seeks any relief, it should have sought before the court in the pending RA, but the court cannot issue any direction. The executive court cannot stop the final decree proceedings with when there is no order in the RA. In that view of the matter, this court finds no reason dismissed.
Number
Your Lordship, at
19.
least consider my second prayer with direct the RA court to dispose the RA or consider my application expeditiously.
However, in the pending RA, if the notices are served, the IA that's filed by the petitioner seeking stay shall be considered in accordance with law as expeditiously as possible. Yes.
Number 19.
I appear for petitioner. Plaintiff's writ petition. Suit is for partition and separate possession and ancillary relief seeking certain documents are not binding. But in that suit, at the stage of arguments, defendant files an application under Order 18 Rule 17 seeking to recall PW1 for recall PW1 to confront certain documents alleged to be a GPA executed by the plaintiff. That is allowed by the trial court against.
Let's see the order.
Please, Manoj. The order is at page 109. Reasoning starts at 113, Manoj.
109.
Yes, Manoj. 113 is the reasoning. May I read, Manoj?
Suit is of the year 2014.
Please. The records reveal that present suit is one for partition and consequential relief. It is also not in dispute that PW1 has already been examined, cross-examined on behalf of the defendants earlier. From the affidavit filed in support of the applications, it is seen that defendants are seeking to recall PW1 mainly for the purpose of confronting her with the GPA dated 25/8/2012, which according to them formed the basis for execution of the release date dated 25/9/2014. Applicants have specifically stated that said GPA was not in their possession at the time of when PW1 was cross-examined earlier, and that the same was traced only recently from the legal representatives.
We'll ask the court to fix one date and on that day to conclude. What is the prejudice to you?
PW1 was cross-examined on that point also.
True. Now we'll fix a date and ask the court to conclude it. We'll fix a date. Why do you want to know by staying the proceedings by this court? What is the purpose now?
That's true, my lords, but the witness has denied that document. Where is the question of confronting that document?
Whatever they want to say, let them say. We'll ask them to complete it in one day. Whatever is the day you want.
Nice.
Dispose it off. Their presence is also not required because I'm not passing any.
For a moment, my lords, the cross-examination of PW1 may kindly be.
They say that that particular document is not in their possession as on that day. No, it's a suit for partition.
Please, my lords, but
What will happen if he cross-examine, confronts the document to you? And
It will
without
be
any
a-
further delay, what could be your apprehension would be the delay of
no,
the
it is
proceedings?
a futile attempt, my lords, because the witness has already denied that.
Do so many things, so many futile exercises in civil proceedings.
Your lordship
One
may
more
kindly
thing
see,
go on.
for a
I'll
moment, my
say
lords,
on one particular day, it should be concluded.
for a moment, my lords, page 82 may kindly be seen.
Not necessary. Please come. The writ petition is filed, agreed with the order dated, order passed in I number 1 and I number 1 and 2 in notice number 3191 of 2014 dated 13th March 2026 by so and so. The petitioner, plaintiff is before this court. The petitioner sought for partition and also a declaration. Suit is of the year 2014. In that, an application is filed under Order 18 Rule 17, read with Section 1 by the defendant on 151 CPC and I number 11, I number 2 under Section 151 CPC to recall PW1 for limited purpose of further cross-examination with respect to the GPA dated 25/8/2012. The court by order impugned has allowed the application. While allowing the application, the court observed that according to the defendants, at that relevant point of time, that document, when they have cross-examined the PW1, the document is not available with them. And as such, they have filed the application to confront this document unless and until the said document is confronted by recalling PW1 that would cause a lot of hardship to them. The trial court by order impugned had allowed the application and observed that no prejudice would be caused to the petitioner. Then counsel appearing for the petitioner submits that he has been examined at length and he has denied the GPA and now it is a futile exercise of again recalling the PW1 and no useful purpose would be served. It is nothing, it is only intention is to drag on the proceedings. Next part. Then counsel, having heard the counsel of the petitioner, put some material on record. No doubt, the PW1 has earlier cross-examined. Now the defendant wants to confront him with the GPA. He says that as on the day the GPA document was not available with them, now they could, they have the same on hand. As such, they want to recall PW1. Considering the apprehension that it is only to delay the proceedings and proceedings, this court has the view that the order impugned will not cause any prejudice. However, the trial court shall fix a date and on that date itself, the same shall be concluded. Accordingly, the petition is disposed of. This court is not issuing any notice to the respondents as no adverse orders are passed against them.
Number 20. We have Person Gowda Patil.
So this is the third case where the execution court entertained an execution petition far beyond the decree which was granted by the trial court. In respect of I numbers 2 and 3, my lord, this honorable court has already entertained the petition and interim order is granted. In this matter, my lords, only notice needs to be ordered to the respondents and connected with the other matters, my lords. I am just filing the
Notice to the respondents, hand summons, list along with so and so.
I've given the numbers.
Yes, next.
Number 21. Ravisha, MD for petitioner.
Your Honor, this plaintiff for the petitioners, they have filed a injunction suit. The Honorable Trial Court granted the interim order by considering the revenue entry and other things. It was challenged by the defendants. The appellant court reversed the order by misreading the unit of the extent. So in the grant certificate also clear.
Read the order from the reasoning part.
The trial court order.
Order we'll see. MA order we will see.
MA order, page number 27. Para number 27, page number 34. The learned counsel.
Page number 34.
34. Page number 27.
Yes.
Para number 27. The learned counsel for the plaintiffs has argued that the property measuring 3 acre 20 guntas had granted to Narsimachari alias Kunta Narsimachari
in survey number 66/6 measuring 3 acre 20 guntas. On perusal of the preliminary records, it appears that property measuring 1 acre 42 guntas granted to Krishna. This is
What
the
is the suit schedule property?
3 acre 20 guntas. Because the 1 acre 40, this is the 1 hectare 42 hairs. It's a unit is changed because 1 acre equal to 40 guntas. If it is read like that, it is not possible to read acre 1 acre 42. It could be read as 2 acre 2 guntas. But subsequent to the RTC, computerized RTC, it was converted into hectare into acres. It is 3 acre 20 guntas. In all the revenue, kindly see the grant certificate, page number 80, and typed copy in Kannada version, my lord. In page number 86, in column number
Page number?
1, 2, page number 26, 1, 2, 3,
Page
4,
number 26.
86, page number 86. 1, 2, 3, 4, 5, sixth column, 3 acre 20 guntas.
Where from me understood as 1 acre 30 guntas?
1 acre 30 guntas, the honorable, the next RTC, it was mentioned in page number, next page 87, Annexure E, the written as in printed form A, Gu, acre and gunta, but in the writing in hairs and H and A, it is second hairs and hectare and hairs. It is 1 hectare 42 hairs. So 1 hectare equal to 100 cent. So 100 cent equal to 2 acre 19 guntas. That is a matrix of units. Hectare is differ acre. Acre is only 40 guntas equal to 1 acre. 100 guntas equal to 1 hectare. So 1 hectare equal, then because it is then subsequent to RTC, it was mentioned in latest.
What is this at page 86?
Pardon?
What is 86? What is 87? Page number 86, what is it?
Page number 86, typed grant certificate. Page number 80 is original grant certificate. It was typed version of 86 in the schedule form. It was granted in grant certificate mentioned 3 acre 20 guntas. But it was mutated in the RTC. Some unit was changes.
Where is that original of that grant certificate?
Grant certificate is page number 80 and 81.
Page number?
80 and 81. In Kannada version is there, but it was.
Where do you get that the extent here?
3 acre 20
Where do you
guntas.
get that? I'm not able to see.
In page number here. Page number 81, column number, last schedule is there.
3 acre 20.
3 acre
Then
20.
what is that 4 acre 38?
4 acre assessment. Assessment, 4 rupees 38.
Now please come to the order.
So now that is only a confusion was get by the Honorable First Appellant Court. By reaching the conclusion, you are claiming excess land, though you are mentioning the RTC 1 acre 42.
Come to that.
Page number, para number 27, 34 page. Shall I read?
Please come.
The Learned Counsel for
The trial
plaintiff
court has granted injunction. What is the injunction granted?
Not to interference.
Has granted injunction in favor of the petitioner, not to petitioner. Granted an injunction restraining the defendants from interfering with the plaintiff's peaceful possession and enjoyment of the property. Against that, MA is filed, and the appellate court had allowed the appeal. While allowing the appeal, the finding of the court is, according to the petitioner, the extent of land is 3 acres
20
guntas, as far as the RTC extract shows that it is 1 acre,
42 guntas. It is a
1 acre.
misreading.
1 acre, 42 guntas. Land council, the petitioner submits that has shown the original grant, which shows 3 acre, 20 guntas. And also he has shown the RTC extracts where they refer to hectares and guntas. It
Hectares
is
and hairs.
acres,
Hectare and hairs.
hectares and
Hairs. Hair, A-R-E.
hectares, and it is submitted that the court and the trial court has rightly understood the same, and the appellate court, construing it as 1 acre and odd, had allowed the appeal. This court has perused the original grant and the RTC extract, and also the order passed by the trial court. In that view of the matter, there shall be an injunction. The order, the operation of the order of the appellate court is stayed, and the order of the trial court is restored till the next date of hearing.
Cell number
Notice and summons.
21.
Yes.
Cell number 22.
Lord, this matter may kindly be posted along with the WP number 239.
Earlier matter.
No, this is separate.
List along with so and so. Notice to the respondent.
Day after tomorrow. Madam.
It's coming day after tomorrow.
It's likely to, because it's also ready for posting. Day after tomorrow, both may kindly be posted together.
Day after tomorrow, list along with the other one.
Obliged.
List 23.
Cell number 23.
The plaintiff, my lord. The petitioner is the plaintiff. The suit for bare injunction, my lord. I filed a suit before the trial court. The defendants who are the stranger to their property, the defendants, they sold the property 1987 itself.
What is IA?
IA not to interfere, my lord.
What happened to that?
The trial court issue notice to the defendant, my lord.
Where is that?
Kindly page number 19, my lord.
Petition is before this court agreed with the order dated 18/6/2026, passed by the principal civil judge JMLC Devanhalli in OS number 277 of 2026. It is submitted that when an application is filed seeking ad interim injunction, the court has issued the suit summons. He has relied on a judgment of a coordinate bench of this court in so and so, so and so. Accordingly, 1 week, notwithstanding the fact that the notice is not served on the defendant.
Already the defendant served the response, defend number 2 to 7, my lord.
I am giving you a further buffer saying that even if it is not also, it should be heard.
Within from
1 week.
1 week, please, man. This.
Cell number 24.
Public.
Jagannath Rao.
I approve for the petition. The plaintiff has filed a suit for declaration that he has got a easement of right to A scheduled property from B scheduled property. Thereafter, the trial court recorded the evidence of PW1, several documents marked. Afterwards, I was stepped into the box. My documents also marked without any demur or protest. Court also has not said that anything. These documents are insufficiently stamped. It requires stamp duty. After some time, he has filed an IA. IA page 43. Your Lordship, I kindly see page 43. IA itself is a misconceived because he has not called for page 43 under section 33(1)(2) and section 34 of so and so, so and so. That for the reasons.
Found the document he asked for the impounding.
No, he should have filed an application, recall the order and impound the document.
Actually, it's a duty of the court to look into
No,
it.
without raising any objection. I mean, even also court after due application of judicious mind, mark the documents. Section 35 says that when once document is marked, it cannot be questioned except under section 58. That is a well settled law. Even the Supreme Court also says that once the document is marked, no question of recall. The Supreme Court judgment is there.
Oh, that is settled law.
Therefore, the impugn order passed by the trial court is patently wrong and contrary to the law laid down by the Supreme Court of this honorable court. It's not the case where he has raised an objection or court has postponed the payment of duty and penalty on the ground that in order to continue the cross-examination, in order to complete the cross-examination, I have not decided the issue of payment of court fee. Court has not stated so. Court has also, after application of its mind, has agreed and marked the documents. Now court says that because he has filed an application, the court has got a power to recall and impound the document. That's not the correct, that's not the correct position of law. That's what, with great respect to learned judge, I'm making my submission. It requires some sort of debate because there are several judgments on this point. I don't want to repeat.
No, what you're saying, there is no dispute about the legal portion you're saying, but at the same time, why should the revenue be lost when some
No,
document
that is
has to
correct,
be
but that is
impounded?
correct. That is correct, Malad. That is correct. My case is another. Second point is it's not a mortgage deed, it's a lease deed. Even for a collateral purpose, Malad.
If whether such an order is bad or not is
No,
another
I
aspect.
have also made a statement before the trial court with my state objections. I may be permitted to use these documents for collateral purpose.
That's what, that we can examine, but
To that extent, Malad, to that extent, I am not agreed, Malad. Your Lordship, I kindly make an observation. So far as these documents are, these documents can be looked into for only collateral purposes as per section 49.
I am on the point, like why should when there is a particular document requires to be impounded, is not impounded, like why should the revenue be lost?
No, that
the point.
that is correct. That is beyond the section, my lord. Your lordship is right. A fiscal statute, there is no question of losing amount to the state exchequer. Lord, moreover, she is a.
When counsel for the petitioner submits that an application is filed, a memo is filed by the respondent stating that the document which are already marked are insufficiently stamped and they have to be impounded and penalty has to be imposed.
Exhibit D4 and D5.
D4 and D5. It is submitted by the land council that once a document is marked in evidence, then another law is if it is an insufficiently stamped, that can't even be marked.
The collateral purposes, it can be looked into, my lord. That's what defendant
For
has.
collateral purpose, when the mark is an unregistered document, a document which has to be registered is unregistered.
No, collateral purpose only to.
It would be looked into for collateral purpose.
Status.
But an insufficiently stamped document cannot be looked into for any other purpose. And submits that the court at a subsequent stage and without an application by the petitioner, by filing a memo, the court cannot take into consideration. Further, it is submitted that he can rely on the said document for collateral purpose. Considering the fact that already these documents are already marked, but however, the court has to examine whether such an insufficiently stamped document without impounding it, can it be admitted in evidence? Is it can all those issues can be reopened, has to be looked into. Hence, considering the same, they shall be stay, notice, and summons.
Stay the impugned. Stay.
Granted.
High low
25. LB Niklingappa.
I beg to appear for
Yes.
petitioner. Petitioner is the plaintiff. He filed a suit for partition of the joint family properties, my lord, and he has paid the.
What is impugned IA?
IA is 13, my lord.
Huh?
IA number 13.
For what?
When the suit was pending, my lord, he has paid a normal court fee of ₹200 as prescribed under the Court Fee and Suit Valuation Act. Subsequently, my lord, the petitioner has been made to deposit 33,000 rupees, something like that, 33,331 rupees towards court fee, my lord. I have produced the challenge, my lord, at annexure.
Now the court has framed an issue and decided on that with regard to the court fees. Come to the impugned order.
Court has not sought for the payment of that amount. The advocate played a mischief and he has made the petitioner to make the deposit of ₹33,331 rupees.
What is that? Advocate means your advocate.
Yes. In fact, the petitioner is a disabled person. Your lordship may kindly see annexure A. He is receiving.
You engage the same advocate or not? The same advocate is appearing in the trial court or not?
Now he has been changed, man.
Let respondents come, notice to the respondents and summons.
Cell number 26,
Much.
Srinivas.
Petitioner. The petitioner is plaintiff number 1 before the trial court, madam. The suit for declaring the A schedule property is a passage for a free movement of the people of the village.
What is the IA?
IA number, I am challenging the IA number 17 and 18, recalling of the DW1.
To the order. Page
Recalling
number.
of the DW1 for the purpose of cross-examination. With respect to the, kindly peruse this page number 68, reasoning part, with respect to the IA number 17 and 18. The last line, my lord. The matter was posted for the
When is
defense.
this order passed?
It was passed on.
It's October 2025, 1
Please,
year
ma'am.
back.
Please, madam.
Why are you questioning this after 1 year?
Please, madam. Parties come now.
Notice to the respondents.
Please.
Hand summons. Yes, 27.
Cell number 27, Reader for petitioner.
My lord, this is where, my lord, the petitioner is ready and willing to pay, my lord, 2 lakhs, my lord, from the date of within 15 days, my lord. And subsequently, my lord, the petitioner's only source of income.
What is the IA now? What is impugned order?
My lord, the impugned order is that the Honorable Executing Court has passed an order, my lord, to execute the sale deed in favor of the decree holder, my lord. The property worth more than 30 lakhs, my lord. I owe only the 14 lakh 10,000, my lord. I have already paid during the execution proceedings, my lord. I paid 3 lakh 25,000, my lord.
Suit is for specific performance.
Please, my lord.
It is decreed.
Please.
No appeal is preferred.
No, my lord.
But then,
My lord, only with respect to payment of entire consideration, my lord, what was agreed, my lord. It was initially for the consideration amount is only 7,20,000, my lord. Subsequently, they have agreed, as per compromise, my lord, they have agreed to pay the total consideration of 14 lakh 10,000, my lord. And during the course of this execution proceedings, my lord, she had paid 3 lakh 25,000, my lord. And she will pay another amount, another sum of rupees 2 lakhs, my lord, in within a period of 15 days, my lord. And the only source of income, because she is housewife, my lord.
come to the order.
Please, my lord.
All this housewife and all in the civil matters that won't work out.
My lord,
That is not,
my lord,
Where is that?
the only submission I want to make, my lord.
Where is that order? Let me look at it.
My lord, ink page number. Annexure A, my lord, in ink page number, my lord, 28, my lord.
What is there at 28?
My lord, in ink page number 28, my lord, 4/7/2026, my lord. It is only said, my lord, the draft sale deed filed, issue commissioner warrant if draft sale deed is approved. My lord, this is the order passed, my lord, in favor of the decree holder, my lord. Once the sale deed is registered, my lord, literally because this very same property was actually pledged, mortgage was created in favor of the SBI, my lord. State Bank of India, my lord, as on.
I didn't understand anything even now. I'm not able to understand what is your submission.
My lord, this property, my lord, this is the residential house, my lord, that has been already pledged to the State Bank of India, my lord, in 2021 itself. My lord, this property was purchased at the time, my lord, as per the, my lord, I have produced this sale deed, my lord, in ink page number 38, my lord.
Where is the judgment and decree?
Judgment and decree was passed on, my lord. That was produced in annexure E, my lord, ink page number 65. As on 18/2/2022, my lord.
What is this order?
My lord, this is a compromise decree arrived between the parties, my lord. And she had agreed to pay the 14 lakh 10,000.
Read over to so and so.
Please.
What it says? File joint compromise memo stating that they have settled the matter for rupees 14 lakh 10,000.
Please.
The defendant has agreed to pay the said amount by 33/2024.
Please.
Failing which, agreed to pay interest at 25% per annum.
As per the joint memo, it is compromised, my lord. And subsequently.
You are supposed to pay the money by 31/3/2024.
Please, my lord.
You didn't pay.
Yes, my lord, I have not.
Then?
My lord, during that time, when they have executed the proceedings, they have filed the execution proceedings, my lord, I had paid 3 lakh 25,000, my lord. And I am ready to pay another 2 lakhs, my lord, within 25, 15 days, my lord. And my husband is working in police department, my lord. I will try to take PF loan, my lord. I will try to clear it, my lord, within a period of 2 to 3 months, my lord. That is all the submission, my lord, because she don't have any financial.
Then leave it.
My lord, the reason is that, my lord, they are residing in the
These are
same
not the
property.
grounds that the courts will interfere in a civil matter of this nature.
My lord,
There was a compromise decree. You are supposed to pay, when you are supposed to pay 31/3/2024,
Please.
we are in 2026. Now you say that grant another, I will pay 2 lakhs, I will pay 3 lakhs. What is that?
My lord, within a short period, it is quite difficult, my lord, because it is already pledged to the SBI, my lord. I am paying the.
Whatever it is, that's not a ground. Please come. The petition is before this court. If you want, I can issue notice.
Please.
Notice the respondents.
Public.
Cell number 28, R. Chandra Kumar, a petitioner.
Petitioner in this case. In view of the rejection of the amendment application filed by the defendant to amend her counterclaim with respect to, my lord, only with respect to change of ward number,
IA number under order 6 rule 17 is rejected.
annexure D,
Suit is of the year 24. What is the suit for?
suit for bearing junction. The defendant, petitioner before the trial court, defendant before the trial court. She has filed counterclaim. Since there is a
What is the suit for?
suit for bearing junction.
What is your counterclaim? You also sought for injunction.
Yes, yes. This honorable court already granted status order. Status order. My lord, in view of the change of the ward number by the CMC itself, after converting to the kata from e-kata, e-kata to e-kata, they have mentioned the ward number 14 instead of 16. At the time of the filing the written statement, there was a revenue documents with respect to ward number 16.
Suit scheduled property and the counterclaim property,
Different properties.
Please show. What was the counterclaim for that property, scheduled property?
Kindly comes to the page number 40, application.
Page number 40.
My lord, before going to that application, kindly comes to the page number 37, written statement schedule. Written statement schedule. 37, page number 37. All the piece and parcel of residential vacant site property bearing number so and so. 16th ward of Shivamogga Municipal Corporation number so and so. Your Honor, at the time of the filing the written statement, and we have referred we have produced the kata in page number 81, which shows that property in question within the jurisdiction of ward number 16. In view of the administrative changes of the CMC, they have changed the ward number as a 14. Accordingly, they issued certificate certifying the change of ward number. That is annexure M. Annexure M.
Come to the order.
Order, my lord. Only ground that after framing the issues, the defendant already entered into witness box, partly cross-examined. Accordingly, this application is not maintainable. I am seeking only change of ward number in view of the certificate issued by the CMC itself. It is administrative procedure. Page number 18.
Please come. Then consider the petitioner's defendant submits that the court had dismissed an application filed under order 6 rule 17. Only on the ground that the trial has commenced. It is submitted that by way of this amendment, he wanted to delete the ward number 16 and insert it as 14, as the municipality has changed the ward numbers after the counterclaim is filed by the petitioner. All these aspects were not considered by the court. Notice, hand summons, stay.
Statement.
Yes, next.
Please.
Cell number 29, Rakshita.
For the petition, my lord. So it was the suit for eviction, my lord.
Where is that report? .1. It's there. Where is that order sheet? When is the matter coming up?
It's on, once again, it was advanced to 15-9, my lord. 15-9.
Yes, please come. The writ petition is filed seeking the following prayer. This is WP number 282484 of 26. This court has called for a report. The learned judge has placed a report stating that due to, as the learned judge is having additional charge and due to other administrative reasons, it could not be disposed of. They could not pronounce the order. It is submitted that by the next date of hearing, the orders will be pronounced accordingly. Concerning the said report, the writ petition disposed of. What are the other two?
The other two, it's all the same, my lord. The next one is, the date is on, once again, 15-9, my lord. And the-
29, 29.1, 29.2 in all the matters. Next date
And,
of
and,
hearing.
the third one is on, just a second.
Whenever is the next date of hearing?
10-9, 10-9.
Whenever is the next date?
Next
of
date
hearing?
of,
Yes, next 30.
great, great, my lord, great, my lord.
All disposed of.
Great,
Common
my lord.
order.
There is one more connected matter, my lord, it's yet to come, fourth matter. Just I would like to please consider that as well.
Why
my lord.
your successive writ petitions, one after the other, not leaving the judge to even give that?
Number 30, Ramesh Kya.
Is advocate on record is not keeping well next week.
Yes, this is matter next week, 31.
Number 31, Rahid, petitioner.
This case,
Yes.
the defendant number 9 and 10. Apart from respondent number 1, all other are the defendant. Respondent number 1 has filed this matter. His lordship has stated yesterday in CRP. He is seeking police protection because we got an order from for construction.
This has to go along with that.
No, it's not. Lordship, he has to, only hand someone may be issued respondent number 1.
Hand
Then
summons.
lordship can decide. Fix a date, lordship, short matter. He is seeking
And summons notice to the
to respond.
respondents.
In respect to other respondent, it may
The
be
memo
dispensed
is
with.
filed by 11th and is the matter on 15th September.
Lordship, in respect to other respondent, barring respondent number 1, the notice may be dispensed, lordship.
Who are the other respondents?
They are the defendants, lordship. They are sealing with us.
Number.
Yeah, lordship. 1, 2, 2.
Notice to counsel for respondent number 1 and summons.
2 to 26, lordship.
2 to 26 memo is filed. Dispensed with. Yes, 32.
Number 32,
Lordship, I am appearing for the petition, my lordship. I have challenged the order passed on IA number 3 by the trial court. Lordship may kindly see page number 18, my lordship. The order on IA number 3 at page number 18 of the petition. The counsel for plaintiffs of the IA 1 and 2, 1 of 26 and 3 of them may be allowed. IA 1 I filed for recall and IA 2 for permittive evidence. Lordship may kindly see the other side has said no objection because I have produced the unregistered settlement deed. The Honorable Court has directed the office to send the documents to the concerned sub-registrar to give report in regarding calculation of stamp duty.
Where is your application? Page number?
My application is at page number 11, my lordship, Annexure A.
No, when an order is passed by the court, then the court will take care of it. What is this application?
Application, because earlier the trial court itself has passed an order directing the office to send the documents to the concerned sub-registrar for stamp duty regarding unregistered settlement date. Accordingly, the office has sent it. In spite of several date of hearings, the sub-registrar has not sent the stamp duty payable unless and it is
An application is filed.
and refused
Taking
and
note
IA3
of
has
the-
been dismissed.
To give report on calculation of stamp duty, it is, the said application came to be dismissed saying that it does not contain any reasons. The land council submits that when already the report is called for from the concern and from several locations as the matter is being adjourned, this application is filed and the court has failed to consider the same. Even the respondents have also no objections for allowing the said application. Considering the submission, stay notice and summons. Yes,
Cell
next.
number 33,
Petition.
Pawan Chandra Shetty.
Defendants are before my lord. My lord, the suit is against the trust, trusteeship and trustees. The lordship may kindly peruse the running page number 59 annexure C.
What is impugned order?
Impugned order, my lord, with respect to the, my lord, the trusteeship has been cancelled with respect to the plaintiff. He has been permitted, my lord, to continue as a trustee. Against the being agreed by the same, we have filed before.
Injunction is granted.
Injunction is granted. My lord may kindly peruse running page number 59 annexure C, my lord. My lord, Praveen B. Tumbe is the plaintiff, who is, my lord, not claimed as, my lord, trustee. Host title, my lord, running page number 59 of the plaint. And my lord, defendants also, my lord.
What is the impugned order?
Impugned order is, my lord, annexure A and B, my lord. That is civil judge junior division and senior.
MA is confirmed.
MA is confirmed, my lord. My lord may kindly peruse running page number 59 annexure C. One of the trustee, my lord, Praveen B. Tumbe, who has filed a suit before the learned trial court, but my lord, not under the independent capacity, not as a trustee. Against the, my lord, other.
See the prayer. Let us see the prayer in the
running page number 63, my lord, paragraph number 13. For the
Seeking a
declaration
that the removal of the plaintiff from the trusteeship is bad.
Yes, my lord. This is the final prayer and interim prayer is, my lord, one and same. Then final prayer has been, my lord, in the stated that.
According to him, he was already removed.
It is already removed.
Where is that?
My lord.
Let's see from the plaint where what he says. Plaintiff has been removed.
Yes,
from
ma'am.
first responding, the plaintiff has been removed from the trusteeship of so and so by making several basis. This is dated 4/7/2025.
Exactly, my lord. My lord, trustee is not a party, my lord, to the proceedings. And no trustee sued, my lord, by the name. Your lordship may kind.
He has filed an application. He has filed the suit.
But
on 16/8 he filed the suit.
But trustee is not a party.
Who are the parties?
Parties, my lord, everyone is, my lord. Defendant not sued in the capacity of the trustees, and trustee is not a party. And plaintiff is also not claimed that, my lord, I am a trustee in the cost title of the.
How it is dealt with by the court?
The learned trial court, my lord, is said that, my lord, it is the first step, first court, that is the learned trial court, at running page number, my lord, may kindly peruse, my lord, 55.
I think both the courts have concurrently held.
Concurrently
Take
fine,
out
but
notice.
that is concurrent.
We'll hear it now at this point of
Concurrent,
time.
my lord, concurrent error, my lord, because.
Oh, that is true.
Trust must be, it's an entity, my lord, under the Indian Trust Act, my lord.
No, that is true.
Trust.
I'm saying, I'll give you a short date, we'll dispose it off.
Because Sharadoso is.
What will happen is, now we can't, what the implication of this order is, he is out of the trust.
Is out of the trust, but trust is not a party. That ambiguity of the order must be protected, my lord. Because there is a force in the order by the learned trial courts, both courts.
What is the order?
Order, your lordship may kindly see.
There is the operative portion of the order.
Annexure B, my lord, first I will come to annexure B. That is running page number 57, my lord.
IN number 2 filed
by the so and so is hereby allowed. Thereby defendants are hereby restrained from excluding
from the activities of Sri Sharada Seva Pratishtha Trust.
Tumbe, Bantawala Taluk,
And how who are these people?
These people are the, my lord, admittedly trustee, but not so as a trustee. Under the name and first, my lord, they are not an independent capacity. They are not, my lord, discharge their duty. They must be sued as in the capacity of the trust. And trustee is not a party. Therefore, my lord, order 1 Rule 9 hit by the non-joinder of necessary party, my lord. The entire suit is hit by non-joinder of necessary party, my lord. My humble submission further is that, my lord, he must be claimed as I am the trustee. That is also not stated in the cost title. The cost title is very much silent with respect to who are the trustees, who are not trustees. In the absence of the trust.
Pass the resolution dated 3/7/2020.
That is, my lord, defend number 1 and 2, 3. Admittedly. But they are not claimed, they are not sued as a trustees.
No, no.
Other trustees.
As a trustees of the trust.
Yes.
By way of a resolution.
Yes.
Huh?
Yes.
Please come. Then comes for the petitioner submits that a suit is filed, seeking a declaration that the removal of the plaintiff from the trusteeship of Sri Sharada Seva Pratistapana Trust, word resolution dated 3/7/2025 and letter dated 4/7/2025, and illegal and not enforceable. It is submitted that the defendants are made as the defendants are made in their independent capacity. They are not arrayed as trustees. Now the trustees are party to the suit. And without the trust being a party, the court has granted an injunction and the appellate court has confirmed it, and the suit has to be dismissed for not making for non-joinder of necessary parties to the suit. Further, he cannot have a relief without the trust being a party to the suit and the trustees in their as a capacity of the trustees to the same, considering the same.
Deeply obliged.
The order of operation of the order passed in MA and so is state.
Obliged. Deeply obliged.
MA and also in IA.
Please.
34, Sagar BB.
My lords, defendant's petition, my lords. A commercial suit, my lords, for recovery of possession, my lords, and for payment of damages. My lords, the order impugned, my lords, is passed under section 12A of the Commercial Courts Act. My lords, the order passed, my lords, is at page number 47. If I may read, my lords, perused IA number 3, since urgent relief is prayed in IA number 2, the said IA is allowed. Hence, the plaintiff is permitted to file suit without pre-institution mediation as required under 12A of the Commercial Courts Act.
This is on 11/5/2023.
Yes, my lords. My lords, thereafter what has happened is, my lords, this defendant has entered appearance, filed wakalat.
Let him come. Let the respondents come.
Difficulty is, my lords, 28th matters listed for arguments, my lords.
When did you enter appearance?
My lords, appearance is entered, my lords, in the year 2023 itself. Thereafter,
We can't stay the proceedings now.
then your lordship may kindly have it on 27th, my lords, because 28th, my lords,
How can you serve the notice? When will you come on 27th?
my lords, there is another connected petition, my lords, writ petition
List along
17254.
with so and so, notice and
27th.
hand summons. Yes. Whenever it's coming, list along with so and so, give the number. Notice to the, hand summons to the.
Lords, my only difficulty is if judgment is pronounced, my lords.
So the problem is whenever you feel that it should be questioned, that's not the day we will interfere, that too in commercial matters. Having kept quiet from 2023, 2026, you say that the suit has to be stayed.
My lords, this petitioner, my lords, has engaged the services of an advocate there. My lords, after filing of wakalat, my lords, written statement is not filed. There is no cross-examination.
List along with that, because it's not appropriate to stay the proceedings basing on a 23 order. Yes.
Still number 35, MS Nagaraj.
Yes.
The connected petition is on 27th.
Yes.
Deeply obliged.
Yes.
My lord, the executing court, my lord, that issued the arrest warrant.
What is that?
That is my 86 page.
Page?
80 page. In page 80 page. My lord, we filed an appeal. My lord, there is a serious dispute with regard to agreement has been cancelled and we paid the amount. My lord, this court has granted a stay, my lord. But it's not a conditional say, then automatically it is not vacated. We filed an application for modification and extension of the interim order, my lord. Because of the reason, my lord, the recent judgment, my lord, matter not been listed before the division bench. That's what we filed an application before the executing court, my lord, to comply that order, what passed by the division bench of this court, my lord. The difficulty is it is not been listed before the court because we filed an application, modification and extension of the order.
What is the suit for?
Suit for money, recovery of money.
How much is what is the decretal amount?
23 lakhs.
When was the suit decreed?
Suit was decreed on, my lord, it is on 19th April 25.
19th April?
25.
And what happened? Have you filed any appeal against that?
Appeal is filed, my lord.
Any-
RF is pending before this court, division bench.
Any stay
Stay has been granted.
granted on the condition?
Condition to deposit certain amount, decreed amount you have to deposit in
There's
the
a
bank.
certain
only.
amount.
Lord, I will read the order also. The entire decree amount has to deposit directed.
Have you deposited?
But Lord, that's what I filed in that's what I filed an application before this court, my lord. Immediately I filed an application. Modification and extension of the time, 8 weeks is granted. See, I filed an application for extension of the time also, even otherwise. But Lord, that matter has not been listed because on the account of this listed judgment, division-based matters RFA has not been listed unless it has been transferred to that.
19.4, where is the recent judgment? Recent judgment is in 2020.
Nan application, my lord, I have filed an application for extension of time
When was
within the time, 8 weeks before I filed an application.
When is that 8 weeks? When is that within time?
My lord,
Be a date for everything.
yes, date of interim order, my lord, on 26 February.
26 February. Yes.
I filed an application on 27/4, my lord, which is not being listed.
27/4, there is no order by the division bench.
Other, my lord, the matter has not been listed because once
That is not the respondent's problem.
I have filed an application, my lord, this pending for
Filing
consideration.
application is not a ground. Now you file a stay petition here. I don't grant stay. Does it amount to granting stay?
No, my lord, it's not. Allah, there is no, my lord.
When there is an order by the court. No, when the court has granted an order in February, we are in August.
8 weeks, my lord, it is ended in April end. I filed an immediately application. I filed.
What is the application filed by you?
I mean, for extension of time.
How
my
much
lord.
time you ask?
My lord, I have asked the time and also modification because that amount is heavy because the dispute is pending.
I will not interfere with this order.
My lord, my lord, arrest warrant has been issued. We filed an application
Go
on
to
26
the court. Go to the court where your matter is pending.
Correct. I filed an application also before the court without following that arrest notice code. Nothing is there, my lord. I entered the appearance. The trial court has granted. The order has not been vacated. He is also entered the appearance in our court.
Conditional order. Automatically it goes.
No, my lord. There's no such order. That's what I read, your lordship, in page 67, your lordship. I would have been no grounds
Subject
for
to
it.
the appellant means that is a conditional order.
Yes, I have to deposit within 8 weeks.
Out of your stay is subject to depositing means it's a conditional order.
My lord,
I think that
it's
is
not,
a plain
that's not,
language.
they are also appeared before the RFA also. They are appeared in the RFA also, my lord. They have served with an application. They are intentionally, they moved the application before the executing court. And the executing court, my lord, in spite of my application, I have been filed. This is the situation where I could not get it an extension of the order to deposit the amount. Arrest warrant without filing.
Deposit 50% now. Deposit 50% now.
Yes, my lord, I will deposit. I will deposit 50%.
When will you deposit? No time. Immediately you should deposit. Already you had enough time.
2 weeks.
Only
Need 2 weeks.
I will
madam.
grant 1 week, deposit 50%.
Yes, 50% before this court I will deposit. 2 weeks time.
Not before the court. Before
I
the
will
very
not
same
seek, my lord, 2 weeks only.
Before the executing court. The land council.
Because division bench judgment, my lord, the order, my lord,
Once the division
deposit
bench
before this
judgment
court, it has to be deposited in National
only,
Bank.
this is only for arrest warrant. But division bench will take care of
My
it.
lord, then, my lord, it is a, my lord, where, my lord, their direction is like this. My lord, again,
If it's a money decree, as per the later judgment of the Supreme Court, the entire amount has to be deposited. It's only for this arrest warrant, as far as arrest warrant is concerned, deposit 50%. Then I'll say on that it is stayed.
Yes.
Land counsel for the petition submits that. The petition is a judgment letter. The suit for recovery of money is decreed. Against that, the preferred RFA. In the RFA, there's a stay granted by the court, subject to the condition that they should deposit the entire amount. It is submitted that they have already filed an application seeking modification of the order and also seeking extension of time that is yet to be listed before the court. In the meantime, the court has issued arrest warrant. Land counsel submits that. Before issuing the arrest warrant, the court has failed to follow the procedure as contemplated under CPC. And the order needs to be set aside, considering the fact that the court has issued the arrest warrant by a single line order without considering any other aspects. And at the same time, balancing the interest of both the parties, this court deems it appropriate to stay the operation of the order dated so and so, to stay all further proceedings pursuant to the order dated so and so, on the condition that the petitioner shall deposit 50% of the decretal amount by 1st of September. Or else the stay granted by this court stands vacated automatically without further reference to the court.
Cell number 36.
Notice
PM
and summons.
PM Sidmalappa.
This case, appear for plaintiff petition, please, Lord. Plaintiff filed the suit for specific performance in year 2006. The fang end of this suit, please, Lordship. The respondent 1 to 3 have filed the 1 Rule 10 application to implead them as a party to the suit for specific performance.
What is, for why they wanted to be impleaded?
They taken a contention that they have got a share in the
Joint family property.
It is not a joint family property. It is the property of the defendant. They have
What is the relationship between the defendant and the implead applicants?
They says that they are for relationship they have mentioned in the affidavit.
Come to the order implement.
Order, I request this honorable court, please, Lordship, running page number 61. The para 8, please, Lordship. In the light of the above fact circumstances of the case, in order to deal with the application under order 1 Rule 10 plus.
It's a very small order. We'll read from the reasoning part.
The reasoning will commence in page number 59. This is an application filed by the applicant proposed defendant. It is a specific contention of the applicant proposed defendant that the plaintiff have filed the suit for specific performance of contract against the sum of the LRs of Venkatappa and Sanjeevamma. Who are the defendant? Venkatappa or Sanjeevamma are not the defendant, please. The suit of scheduled property belongs to Venkatappa and Sanjeevamma, died leaving behind V. Munivenkatamma, V. Narayanamma, V. Narayanappa, V. Govindappa, V. Gopalappa, Krishnappa, and among them.
According to them, they belong to the said family. You are not impleaded them as a respondent to this.
No, he is not a party to this agreement, please, Lordship.
Not agreement. No, the agreement holder is no more.
The agreement is holder is there. All are the defendants.
Perform against some of the LRs of Venkatappa.
They says that some
Who are the defendants?
of the legal.
So you have impleaded somebody as LRs.
No. I am not impleaded somebody, please, Lordship. Who are the executant of the sale agreement? I have made a party. They died during the pendency of the suit. I have brought on the record.
That is what their case is. That you have not brought all the LRs on record.
He is not a necessary party. They have not executed the sale agreement, please.
Why
Lordship.
did you bring the LRs on record? Original, whoever has executed the agreement is no more. You have brought the LRs on record.
Sorry. The who are executed the agreement, they are the parties to the proceedings.
Then what is this?
They have pleaded that type.
No, please look at it. For the plaintiff has filed the suit for specific performance of contract against some of the LRs of Venkatappa.
That is the wrong version. That is the wrong version. I'm not for.
Your plaint.
I request the plaint, please, Lordship. In page number 15, the plaint pleading is running in page number 17, para 3, please, Lordship. The plaintiff submits that the defendants joined together agreed to sell the properties land bearing survey number 55/1, measuring 1 acre, 3 guntas and 3 guntas of Karab, and the land measuring.
Why are you denying it? You have brought the LRs on record.
During the pendency of the suit, they have died, Lordship.
That is what I am also, that's what I understood.
They are not the legal heir of Narayanappa. I request this honorable court, they are not the legal heir of Narayanappa. They are not legal heir of Gopalappa. They are saying that they are legal heir of some one Munivenkatamma.
Problem is, unless and until I understand the case, you can't get an order, isn't it?
Please, Lordship.
So you have to make me understand, or you have to answer to my queries.
Please, Lordship.
I said, as according to their case, you have brought some LRs on record.
Please, Lordship.
That you are denying from the beginning. That is what the order says. Now, whether these people are LRs of those persons or not is a different issue. So you have filed a suit for against the defendant.
Please.
And later defendant is no more, you brought the LRs on record.
Please.
Now, it is a contention of these impleading applicants that you have brought only some of the LRs, but not all the LRs is their contention. Not, is it correct or not? Their contention.
Their contention is correct.
Yes.
My humble submission, please, Lordship. They are the legalist. I request this honorable court, their application affidavit in page number 48, please, Lordship.
Sri Narayanappa is the original the defendant. He died. Then you
Please.
brought 1A Srimati Shakuntalamma.
Please,
Then
Lordship.
2
Rajamma.
2 is Rajamma, Lakshmamma,
Lakshmamma, Varaprasad,
Varaprasad, then
Hariprasad,
Hamsa Kumari.
Kumari.
7 Srimati Shantamma.
Shantamma.
She died. You
Please.
brought 7A Srimati Sujata.
Please,
daughter.
Lordship.
Yes. Now please come to the application filed under order 1 Rule 10.
It
Where
is
is
in,
that?
in page number 48, please, Lordship.
Yes, please come.
Affidavit para 3.
Yes, let's read it.
I further state that the suit schedule property belongs to M. Venkatappa and Sanjeevamma, who died leaving behind V. Munivenkamma, V. Narayanamma, V. Narayanappa, V. Gopalappa, V. Krishnappa, and among them, Munivenkamma died. Narayanamma died leaving behind me and succeeded to her share of the property. Narayanamma and Gopalappa and Krishnappa who also died, and similarly some of their Yellas also died. And however, the second applicant is my brother and third applicant is son of my another elder sister Adi Lakshmi. And according to I have enclosed the detailed family tree. They are not the children of Narayanappa or Gopalappa or Krishnappa. She claiming that one Muni Venkamma.
According to them, that property belongs to all of them, and but somebody has executed the agreement in your favor. They are claiming interest in the said property.
My humble submission before this honorable court where I can refer the Supreme Court judgment in the suit for specific purpose.
Which judgment is that?
Kasturi.
Kasturi, after much water has flown after Kasturi. You should look at the recent judgments.
Yeah, my humble submission before this honorable
That
court.
Kasturi, that position is diluted now. Now, the recent judgment of Justice Pardiwala says that the subsequent purchaser or anybody,
they are not the
not
subsequent.
purchaser, anybody who has interest in the property is a necessary, is a proper party.
In this matter, please, Lordship, it is a suit for specific performance. I request this honorable court, please, Lordship, passing the order, the trial court come to the conclusion that.
Notice to the respondents, hand summons. Yes.
Cell number
I
37.
request for stay of the order, please, Lordship.
I'm not convinced.
Janardhan G for petitioner 37.
Yes.
Lordship, I have filed a writ, this petition for quashing of the order. The prayer is in page number 11. This is the order passed by the 4th additional civil judge in JMF.
All that not necessary. Where is the IA? What is the IA is sufficient?
IA is in annexure.
Where is the impugned order? Page number?
Page number, impugned order is in page number, annexure J, page number 52.
52.
And the order you'll find in page 55, sorry, 57. Actually, the IA was filed for
Order 26 rule
appointment
9
of-
is dismissed
Yes,
with
yes, my
cause.
lord.
Please
Yes.
come to the order, come to the reasoning part.
Says the reasons are nothing but it is the objections filed by the defendant, by the plaintiff in this case. I am the defendant in the OS number 255. So whatever objections has been filed, accordingly is passed without proper reasons. The IA have filed for appointment of commissioner to take measurements. There is an encroachment of the land. And both plaintiff and defendant, both of them have filed.
Where is your application?
Application is annexure G. Annexure H, my lord. Oh, sorry. Annexure G, my lord.
Page number?
Page number 47.
47. What is the suit for?
The suit was filed for declaration and possession, and also there is an encroachment done by the respondent hearing.
Then comes to the petition substance that an application is for seeking appointment of the advocate commissioner that came to be dismissed by order impugned without recording any reasons. It is submitted that he relied on the judgment of the coordinate bench of this court in Sadaksharappa so and so. Considering the same, they shall be stay of all further proceedings. Notice hand summons. Yes, next.
Interim order, my lord.
Interim order granted.
I'm sorry.
Obliged, my lord.
I'm sorry to mention. Earlier matter, please.
38.
Notice to R1 to 3. Others are not a necessary party. I
What
may
are
be
the others?
dispensed. I file a memo.
R in the earlier matter, R1 to R3, council hand summons. Remaining are
4 to 19 are dispensed.
4 to 19, the memo for dispensation. Yes, next.
Cell number
My lord,
38.
small inconvenience of it. My mistake, I brought a different file. Can you have it on Tuesday, my lord?
Tuesday. Yes, next.
Much obliged.
Cell number
39.
39.
Like to appear for the petitioner in this matter, my lord.
Yes.
The petitioners filed an interim application in the FDP proceedings under Order 1, Rule 10, Subclause 2, my lord.
What is the suit for?
Suit for partition and separate possession, my lord. I am the bona fide purchaser for value subsequent to the filing of the original suit number 1 of 2021.
From whom you purchased?
From the defendant number 6, my lord.
What are the, any?
Item numbers 2 and 3 of the suit scheduled property belongs to me. That's an admitted fact. That matter has been gone into by the learned trial judge. The only reason is that the effective preliminary decree cannot be changed by the trial court, my lord, if I am implicated as a proper and necessary party. No, my lord, the brief facts are this, my lord. The plaintiff is none other than the daughter of the defendant number 1, my lord. A suit for partition and separate possession comes to be filed by her, challenging one sale deed dated of 2016, made by her father in favor of the defendant number 6. I purchased from the defendant number 6 during the pendency of the litigation.
What happened to that? What did the court say?
The suit has been decreed, my lord.
And what about the sale deed?
The-
Your rights are not protected by the court.
No, it's not protected by the court. What happens this, my lord? A collusive suit comes to be filed. I'll be able to demonstrate this, my lord.
Then file an independent suit saying that that's
That
not
is there, my
binding
lord.
on you.
Now what has happened, my lord, in the FDP proceedings? Now, my lord, why I am a proper and necessary party is for this reason, my lord. Even if there is an equitable share for the defendant number 6 therein, my lord, I have purchased it from him. So my right, title, and interest ought to be protected, at least for the sake of equitable partition. The other challenge for me is this, my lord, by the order of the
No, where is the question of you getting the same property?
that is not there, my lord. Same property as such, I cannot directly claim. But if at all the defendant number 6, now, my lord, only one submission is this, my lord. The defendant number 1 is my father. When he makes out a sale deed in favor of defendant number 6, clearly in the sale deed, my lord, he writes that for the interest of the minor children, I am selling this suit scheduled property for the educational purposes. That is there in the contents of the sale deed. Thereafter, my lord, her daughter, defendant number 1's daughter, files this original suit. In the original suit, my lord, defendant number 1 to 5 or the family members have a single advocate. They do not file the written statement. The entire plaint has been uncontested, my lord. And virtually like an ex parte, the decree comes to be passed against.
We'll give a short date, notice to the.
No, my lord, only thing is the FDP proceedings, now court commissioner has been appointed, his report has been put up.
Short date, I did not grant an interview.
All right, my lord, may I only seek this much, my lord. The FDP proceedings may be resultant of this writ petition, only the final decree.
Now, list this matter on September 2nd, if the hand summons are filed by September 1st. The memo, the hand summons are served and memo shall be filed. If memo filed, list the matter on 2nd, if it is filed on 1st. Yes.
Cell number
Great.
40. Vijay MN.
I appeal for petitioner, my lord. Rejection of permission to file written statement. Rejection of permission to file written statement, my lord.
Commercial suit or a normal suit?
It's a suit for partition, my lord.
How much delay?
65 days delay.
A memo, the land counsel for the petitioner's office that the court has failed to take the written statement on record as it is filed beyond 65, beyond the 120, with the delay of 65 days. It is which he relied on the judgment of the coordinate bench of this court, where the court, even after the amendment to the CPC, still in deserving cases, the court can condone the delay, considering the same. There shall be stay of all further proceedings, notice and summons. Yes, next.
Cell number 41. Madhav Balaji Kashyap.
Connected matter arising in the same proceedings, lordship already granted stay. Connected on notice may be ordered.
What is the same proceedings?
So what is happening in this partition suit?
What is that order? Take that order.
The lordship. But in the suit for partition, at the time of not final arguments, they introduce a will. That will comes to be challenged, it comes to be marked on 4th of March 2026. I seek not the veracity of the will, and I get a response on sub register, such will does not exist.
No, what is this application?
But this application is sought under section 39 to be examined before the before the forensic expert. That will, that comes to be rejected only on the ground again delayed. Therefore, my lord, in other case, there's already a stay, your lordship is.
List along with so and so.
Please, my lord.
List along with WP number
My lord, it is,
3337 of
Please.
2026.
the notice may be ordered in this.
Notice handsome.
Oblige, please.
Yes,
Bill
next.
number 42.
Your
Madhu
Lordship,
Gowda.
This petition is, the petition is before this honorable court seeking for speedy disposal of, the miscellaneous petition that is
Keep
pending.
that mic this way so that at least there is a purpose of that.
Your Lordship, the petitioner is seeking for speedy disposal of the,
Miscellaneous 29 of 2016.
please, Your Lordship, before the senior civil judge JMFC Devanelli, Your Lordship.
The writ petition is filed seeking the following prayer. Registrar Judicial is directed to call for a report. Yes, 43.
Bill number 43.
It's the matter on 20 Saturday.
Please, Your Lordship.
Yes, 43.
43.
4
E.B.
months
Shivakumar.
delay in filing written statement.
Commercial suit.
No, my lord.
It is submitted that there is a delay of 4 months in filing the written statement. Same like in the earlier order. Yes, notice and some.
Interim stay one because the proceeding.
44.
Bill number 44.
Senior held up in other court, kindly pass.
Pass over.
Cell number 45.
Impugned order is for,
Why you without a caveat, you are coming and standing, he got shocked. Yes.
Apologies, my lords.
Huh?
My apologies.
impugned order is for,
No, court is not, he shocked. Yes.
impugned order directing the petitioner to undergo DNA test, my lordship. It's a suit for partition. The matter was posted for final arguments. At that stage, they filed an application to direct the petitioner to go. The impugned order, my lordship, the trial court has failed to highlight.
Here before the court on so as to enable the concerned official medical officer to draw blood sample to send the same to FSL to conduct the DNA test. So you're asserting it on what ground? If by conducting this, if the dispute involved in the case can be decided in a more scientific manner, that is what is the purpose. So how is it bad?
Lordship, the plaintiff therein has already led the evidence. They.
No, it's good. It's good for all of you. It's
My lordship, the
scientific
trial court is
evidence.
silent. Why the court cannot come to the conclusion based on the evidence produced by them, my lordship?
That is one aspect. And the other aspect is, what is wrong with this order? You have to, when you're assailing the order, you have to say what is wrong with it.
My lordship, it's a clear-cut violation of right to privacy, my lordship. There is an observation made
There
by
is
the
a law
honorable-
on that. Where is that? Produce it.
But in fact, the trial court has extracted that judgment, my lords. At page 60 or impugned order, the trial court extracts that judgment as my lords indicated.
Look into it. Look into it. Come up with judgment.
My lordship, but they have directed to undergo test on 28th, my lordship. They
It
have-
may be heard on 27th, my lords. We'll be ready. We'll place all the judgments on.
27.
Yes,
List on 27.
Grateful.
Number 46. Manjunath Prasad HN.
Writ petition become infectious.
Then counsel the petition submits that the petition has become infectious. Accordingly dismissed as infectious. Yes, 47.
47. Tahir.
Lords,
You for the respondent.
I for the respondent.
No representation on behalf of the petitioner. List in the month of, list on 28th of September.
My lords, can it be listed a little earlier, my lords? Because this order has already been passed. It's not been challenged. There's suppression of facts here.
That's what anymore, I'm just adjourning the matter.
Because I learned that there was an interim order and then they just want to.
Interim
drag
order
this.
is granted.
Yes, my lords.
Look at it.
Passed over, my lords.
No, let's, interim order is there. No interim order.
That's what I was told actually because
No, there is
I have
no
not
interim
been served
order.
the copy.
No interim order.
No,
Yes. List on, no representation for the petitioner. Counsel for the respondent is present. List on 30th of September.
My lords, can it be listed a little earlier, my lords?
Number 48.
When there is no order, why are you bothered? No stay.
For the petitioner in this case, kindly pass over the matter.
48.
48.
Yes, pass over. 49.
49. 49. M.B. Maheshwarappa.
Respondent. No representation. List in the month, list on 29th of September.
Cell number
Plus 50.
50.
Here for the petitioner, Millards, petitioner's counsel, Millards, on record counsel's wife is admitted in the hospital, Millards. Could your lordships have it next week, Millards?
Tuesday.
Millards, next week any date, Millards.
Tuesday.
Please, Millards.
Yes.
Mobilize.
51.
It is submitted that there is personal inconvenience to the counsel for the petitioner. List on Tuesday. It's 51.
51. Basavanna.
I'm for the caveat respondent in this matter.
Papers are served.
Papers are served, madam.
No representation. List this matter on 1st of October. Is 52.
Serial number 52. 52.
For the petitioner, Your
From
Lordship.
Sujirika.
Served, papers are served on the caveator?
Yes, Your Lordship.
Yes.
Your Lordship, the petitioner is a defendant in the suit. The suit is for injunction and declaration filed in 2016. And the impugned order was passed on 8/6/26. And the petitioner feels highly like the reasoning given by the trial court to be unjustified
Order.
because. So, Your Lordship,
Where is the order?
the orders in Annexure A, Your Lordship, in page 27.
Page?
27, but kindly refer to page 30.
No, petitioner is feeling, but the court is not feeling.
Yes, Your Lordship.
27.
Page 30, Your Lordship.
It's not page 30.
It's the last page of Annexure A, Your Lordship.
Under Order 9, Rule 10(2) is allowed. The plaintiff is permitted to plead proposed defendant number 39 to 41. You are the?
Defendant number 39.
You are the purchaser of the property.
Yes, Your Lordship. But the contention that the petitioner is making is that we've already successfully defended this suit against the same plaintiff for the same scheduled property for the same cause of action 2 times already for the past 10 years. So under Order 9, Rule 9, as well as Order 23, Rule 1, there's a statutory provision prohibiting them from impleading us into the suit, Your Lordship. Because in the first suit, the plaintiff itself has prayed to withdraw us from the suit, Your Lordship, and the same can be found in page 113. And in the second suit, they have, through their own negligence, the suit was dismissed, Your Lordship. And after that, a year later, now they're impleading us for the same cause of action, again for the same scheduled property.
Please come and counsel the petitioner submits that. Earlier, in a similar suit, the petitioners herein were impleaded as defendants and later?
Pardon?
In earlier suit, you were impleaded and later?
In the earlier suit, we were the primary party, and they withdrew us from the case.
That later they were deleted from the array of parties.
Yeah, that came to be disposed in 21. We were withdrawn in 2017.
2021. Now with the same cause of action, another suit is filed, and they're shown as parties to the, and they are made parties to the very same they are made parties to the suit. The trial court has failed to consider any of the objections raised by the petitioner.
Also in the second suit, Your Honorship,
and in a mechanical manner had allowed the IA considering the same stay.
So number
Stay of the
53.
operation of the order dated so and so. Notice and summons. Caveator appearing for whom? Only one respondent. I don't think one. There must be many. Notice to the other respondents. Caveat is filed. Look at it on behalf so and so. For the other respondents, notice and summons.
Your Lordship will be filing an application to remove respondents 2 to 39 because they're not necessary parties. Because
A memo is filed seeking.
not
Write it
in
and
the
give.
next hearing. In the next hearing.
No, if you want them to dispense with notice to them.
Yes, Your
you give
Lordship.
a
At least, okay, by end of the day, can I? Because I don't. Yeah.
Memo is filed seeking dispensation of notice to respondents 2 to 39.
39.
39.
Yeah.
Dispensed with. Any of one is already caveated is there. List is matter in the month of October. Yes.
53. Kashyap and Nayak.
Lordship, serial number 53 and 54, Lordship, I appeal for the caveator. I seek for a short accommodation in this matter, Lordship. I appeal for the caveator in this 53 and 54.
Caveator can't seek adjournment. Caveator can only make your submissions because it's their case. If there is urgency, we have to hear them.
Lordship, in this matter, senior counsel is being
Yes.
engaged.
My lords, I have a small submission. My lords, the caveator or the respondent has already entered appearance here. The matter before the trial court is listed on Friday, my lords. They may kindly be directed to file their objections before the learned trial court, my lords. However, and the petitions may kindly be disposed. However, there's a small submission, my lords. Due to the urgency in the matter, there may be a direction issued to the learned trial court to fix a timeline in order to hear on the application on merits, my lord.
So you're telling that the court should allow this writ petition, ask them to file the objections before the trial court, and on the top of it, there shall be a direction to dispose of the matter expeditiously.
Dispose of the application, my lords, due to urgency.
Let's this matter when you want.
I seek for a week.
Tuesday. This is the matter on Tuesday.
Grateful.
Yes,
Request
lords.
of land counts for the respondent. 54 also same?
53 and 54.
For admission matter, cell number 55.
I beg to appear for the petition. Lord, my 7 rule 11 application came to be rejected by the trial court, my lord.
Where is the respondent? Some other day?
There may be stay, my lord. If they stay, they will definitely come, my lord.
2020.
And there is a prima facie, my lord. I will take 1 minute to establish. He was present, the
Clear it,
delay is
clear it.
condoned.
Take a chance in the next roster. List it on 9th of September. Yes, 56.
Cell number 56.
This also, next month. 57.
Cell number 57. Nagaraj
56, I am for
Jasi.
respondent, just admitting that's all, my lord.
57.
50, I am for the petition.
57, 25 CRP. Notices are served. We can hear later. List on 16th of September.
Well, is it all statement?
58. Look at it. If any of the matters
Date
stays
may be
there,
given, my lord.
extend. If it is there, it will be. Otherwise, it will be considered later. 58.
58. Bhagwan. SG Bhagwan.
Yes, this also. In the month of September, 24 September. Look at it. If interim order is there, extend. 59.
59.
Please pass over the matter.
Huh?
Pass over the matter.
Which matter?
59, madam.
26 matter. Yes, I'll hear 26 matter. Pass over.
Please.
Yes, 60.
60. 60.
Pass over.
Cell number 61.
Pass over.
62.
I'm referring for the petitioner.
Which matter?
It's in 62, serial number 62.
Who
Kindly
appears
pass
for-
over.
Respondent K. my lord. Wakala is my lord. We take a day after tomorrow, I'll go on with the matter.
Day after?
Day after tomorrow, Thursday.
They're asking for day after tomorrow.
Kindly, my lord, so what is the issue it was, my lord? The petitioner.
Day after tomorrow, he wants it. Can't wait till day after.
Kindly.
Yes, day after.
Please.
At the
And
request of
develop
none counts for the respondent. 63.
60 minutes, 60, break for time.
Huh?
60 minutes, serial number 60.
60? It's passed over. Yes,
Yes,
63.
opponents are responding. Senior is
63.
Cell number 63. Nikhil K. Ramurthy HS.
Yes, we'll continue later.
Urgency or
One small submission, madam,
Serial
extreme
number
urgency,
84.
madam, in this matter.
There is an urgency that wife and husband has instituted wife has instituted a partition case against her, wherein he is not even giving maintenance and she is living separately but not even ready to sell the property, wherein he has admitted that they are the joint owners and there is also a sale deed. And here on judgment on admission, the lower court has dismissed my application, and now she has no other way other than selling her share of property and going ahead with it. Finally, it may be heard today, your lordship.
That's not the urgency. Yes.
Plus 85.
Only matters that has to be taken up 230. If 230, why?
Well, serial number 85, my lords.
Yes.
It is a educational institution. There's some law and order situation which has been arisen. Their FIR has been filed. Suit has been stayed on payment of court fee, my lords. That can be decided during the trial. My injunction applications cannot be considered by the court because there is a stay in this matter.
Yes.
That is only the request.
230, yes.
Much.
It's a fresh
Well,
matter.
yeah,
my
thank
lords.
you,
I'm
Kumar.
requesting for fresh matters. Memos are not required. It will come. Yes.
Fresh matter. My lords, 31st is the judgment, my lords, in the trial court. 711 rejected, my lords, after, my lords, the chief of PW1 I have filed. But now, without arguments, my lords, 31 it is posted for judgment. Lords, order 7, rule 11 is rejected. But 35, my lords.
Anyhow, either ways you will file a first appeal.
My lords, but my lords, jurisdiction is an issue. My lords, may I have it, my lords, on Friday, my lords, I'll take a chance because, my lords.
It will come if you.
Lords, because
KB matter, KB matter.
Serial number.
Right, serial.
They are not let me to file the
There is
registration.
one more ground. The property is already attached.
That's
Your
not.
My lord.
Serial number 61.
KB matter.
But as if like a family court matter, civil matter, there is no urgency of that nature.
KB matter.
Huh? When was the attachment order?
My lords, in this
My lord,
matter.
serial number
Complete.
9.
Complete
My lord,
knowledge.
serial number 92, my lord.
Then,
KEB matter, KEB matter, my lord,
Serial
KEB
number
matter.
92, my lord, is.
My lord, KEB matter.
ಮೇಡಮ್ 230 ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಲಿಸ್ಟು. ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಹೇಳಿ.
ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಲಿಸ್ಟು 230ಗೆ.
ಅನ್ಕೊಂಡಿದೀವಿ ಸರ್, ನೀವು 230ಗೆ ಅದ್ ನೋಡ್ಬೇಕು. 230 ಕನೆಕ್ಟ್ ಆಗಿ ಏನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇರುತ್ತೋ ಅದ್ರ ಪ್ರಕಾರ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ, ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. 230ಗೆ ನೀವು ನೋಡ್ಕೋಬೇಕು. ಅದು ಬೇರೆ ಏನೋ ಕರೀರಿ ಅಂತ ಅಂದಾಗ ನಾನು ಕರಿಬೇಕಾಗುತ್ತೆ.
ಆಯ್ತು ಮೇಡಮ್, ಓಕೆ ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಆಗುತ್ತಾ ಪಾಸ್ ಓವರ್ ಕರೀರಿ ಅಂತಾರ ಅಥವಾ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಕರೀರಿ. ಅದು ನೀವು 2:30 ಒಂದ್ಸತಿ 5 ನಿಮಿಷ ಕನೆಕ್ಟ್ ಆಗ್ಬೇಕು.
ಆಗ್ಲಿ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು ವೆರಿ ಮಚ್, ಥ್ಯಾಂಕ್ ಯು.
ಏನ್ ಹೇಳಿ ಸರ್? ನಾವೆಲ್ಲ ಮೆಮೊ ನಾನ್ ಬದಿಯಲ್ಲಿ ಅಲ್ಕುಡಿಯಲ್ಲಿ ಏನದು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್? ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಗೆಲ್ಲ ಮೆಮೊ ತಗೊಳಂಗಿಲ್ಲ. ನೀವು ಅಲ್ಲಿ ಕಂಪ್ಲೈ ಆಗದೆ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿ ಅಲ್ಲಿ ಹೇಳಿ, ಹೋಗಿ ಹೇಳ್ಬೇಕು. ಅರ್ಜೆನ್ಸಿ ಇದ್ರೂ ನೀವು ಕಂಪ್ಲೈ ಆಗ್ಬೇಕು. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡ್ಬಿಟ್ಟು ಅವ್ರು ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕು. ಆ ತರ ಡೈರೆಕ್ಷನ್ ಇದೆ. ಹೇಳಿ, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೇಳಿದ್ದಾರೆ.
announcement.
Make a mention, my lords. Serial number 41, my lords. Notice was ordered. There are 56 respondents, my lords. However, only the contesting respondent, only respondent number 1. I
Take
think the
that
memo
memo.
to dispense 52, 2 to 56.
My lords, with your permission, my lords, list 2, serial number 6, my lords. There is an IA for stay, my lords, and I've also filed my dispensation application, my lords. If the matter could be taken up today, my lords, because the trial court is proceeding and is insisting on carrying out the amendment, failing which it will be dismissed, my lord.
Serial number?
6, list 2, my lord.
Serial number 6.
List 2, serial number 6, my lords.
There are so many non-taking of steps.
My lords, the remaining respondents have been placed ex parte. I have also filed my.
So what is urgency now? When the matter is going to come up?
On 28th, my lord, before the trial.
28th, it will come on 27th.
My lords,
Yes.
list 2, serial number 11.
Already over, ma'am. All mentionings in
was-
the afternoon, not now. Yes, call the list.
Please.
Hmm? Yes, that's what. Give it to him. Yes. Accordingly, the writ petition is allowed. The order dated 18/11/2009 is set aside insofar as liberty is given to the bank to recover the amount from dependent number 1 to 3 and also from property shown in the OA schedules, and the matter is remanded back to the tribunal for fresh consideration. Proclamation of sale published in the dated 17/5/2015 is set aside, and the tribunal shall consider it expeditiously.
For the petitioner in this matter, my lords.
Appear for respondent, my lord.
Accordingly, the writ petition is dismissed, reserving liberty to the petitioner to raise all their contentions before the special court constituted under the Act.
Great.
Grateful, Your Honor.
Appear for respondent, my lord.
This also it is disposed of giving liberty to the petitioner to approach the competent authority. Whenever the petitioner files an appropriate application, the competent authority shall consider and dispose of the same on its own merits in accordance with law.
Great.
For the petitioner, please.
Respondent number 1, seeking time to file objections.
Huh?
For respondent number 1. Oh, sorry.
The writ petition is dismissed. However, it's made clear that this court has not decided the petitioner's entitlement to refund interest or any other relief with regard to the sale certificate. All these questions are left open for consideration before the competent forum in accordance with law. Accordingly, writ petitions are dismissed. It's left open to the petitioner to avail the appropriate remedy before the DRT.
Petitioner, Your Lordship.
This court is not inclined to grant the prayer that the Buds Act is subservient to the Surface Act. However, it is made clear that the secured creditor has a valid and duly registered interest in the property and is entitled to the benefit under Section 26D and 26E of the Surface Act. The statutory priority cannot be defeated merely on account of a subsequent proceedings under the Buds Act.
Much obliged.
The order dated 31/10/2025 passed in so and so by the Deputy Tribunal is set aside and writ petition is allowed. The matter is remanded back to the tribunal for fresh consideration subject to the following directions. Certain directions are issued. The writ petition is dismissed.
For the respondent in 9.1.
The proceedings initiated with the bank pursuant to the notice under Section 13(2) of the Surface Act are set aside. The bank shall consider the reply given by the petitioner under Section 13(3) of the Surface Act and shall proceed in accordance with law, keeping in mind the MSME framework.
Grateful.
Done. Call the 230 matters. Serial number?
I asked for passover, my lord, because council is there in total 16, my lord, on his legs. Currently, there is another 230 matter.
That 230 today specifically on my request.
Yes, my lord.
Where is that? This is serial number?
95, ma'am.
Impugned order is an order on 711 application filed by one of the defendants.
Yes, call the senior.
I'll call him.
Next matter.
Great.
Yes, what happened?
Fine.
Fine.
My lord, with Herculean efforts, my lord, because there were a lot of filing formalities in the Supreme Court. My lord, we just pushed and my lord, we have placed detailed affidavit precisely agreeing to my lord act as per the.
It's a kind of win-win situation for both.
Yes. Now, my lord.
Finally, they got an undertaking from you.
Yes, my lord. Now
you
they
got
will
an
have,
order for
which
another
they should
1 month.
Yes, my lord. All
But
their
for the
rights-
honorable court's direction.
Now, my
let
lord,
me read
all
this
their
once.
rights,
Please to dismiss the
all
captain
their rights
while allowing the
will, my
three
lord,
months time to
get onto the rails only after 30th September. Now, my lord, till 30th September, my lord, the execution has to be
The
stopped.
affidavit undertaking duty so that.
Yes, have you just now he has given you?
Or being taken on, just now.
Look at it.
Just be taken on record in the register of this enclosed herewith for being taken on.
Mr. Hegde is very meticulously reading.
I'm engaged
I
in the
don't,
technical.
my lord, would it be such, my lord, I would, knowing that Mr. Hegde is there against me, my lord, would I venture?
Is it words of comment or just not to read it?
And Mr. Hegde is, my lord, inter alia, my counselor. My lord, knowing his position, my lord, would I venture to give him a wrong document?
I think in the light of this,
let the execution case be on, my lord, because it has been on from
will give you
January.
liberty to file appropriate application.
No, 1 minute. What's mentioned last para 4.
Yes.
Subject to what my
It's only
friend
para
says.
2. Where from you're getting para 4?
No,
Or before that?
before that.
That's a Supreme Court.
The letter submitted to the
they are
registrar.
given. Then the next is the
Supreme Court
affidavit of undertaking at para number 2.
Yes, I am reading that letter, para 4.
Yes.
It's further respectfully submitted. The original of the said affidavit of undertaking has been sworn at Bangalore, is in the process of being transmitted to New Delhi.
No, now, my lord, that affidavit was made in the morning. My lord, this has come just, my lord, some 10 minutes before.
That's right.
When we made the affidavit, my lord, that was still under process. The cover page, my lord, is.
I'm not finding anything, I'm just trying to clarify. We're only saying it shall take some time. In the interest of coming in the time, it's paid the scanned copy, so and so may be permitted, because the original has to reach there and has to be filed. Unless the original is filed, para 4 also says, I have nothing, no complaint. What they say is.
Because it is like this.
Please.
Whether it is filed before the Supreme Court or this court,
Yes,
they're
yes.
filing it before a court of law and undertaking.
Yeah, exactly.
So
Please.
it's not
what we shall do is,
whether that is.
I will not stand on any. We will not stand on any formality. What my submission is, now that they have said we believe it, it will reach the Supreme Court in 3 or 4 days.
It's filed today.
No, what
today.
I'll do is, I'll
Please.
again take up this matter in the next week.
Exactly.
So,
and so
in
that
the
by the time it will
meantime,
reach and they will
By the
report.
time whether that is number, it has reached the Supreme Court or not.
It has,
and
my lord, reached. In fact, your
No, no,
lordship
no.
sees, my lord, it is a date seal. Kindly, my lord, see at the first page. My lord, it's
No,
an
I'm not
affidavit
telling you
filed
without produced.
with the office of, my lord, the Honorable Supreme Court today. On the left-hand side, my lord, the square seal, which is, my lord, quite hazily visible. It is filed, in fact.
Anyhow, all
Your lordship may kindly call it next week, my lord, so that I
Yes.
should be able to file a better proof.
So,
And it could be
now-
even traceable online.
Yes.
Ravi Shankar, so and so.
Where is the order impugned? Page number?
Now, my lord, the order impugned, my lord, is at page number. Your lordship should kindly have.
No, this one last para 2, last sentence, that cannot, last lines. And also to claim such rights as would be available to us under law, nothing can be stated.
My lord,
Once,
I'll see.
no. Once Supreme Court says something, then we cannot say we will exhaust other remedies. We maybe have other rights. Last sentence.
1 minute. Whatever he might say,
Please.
whatever he might say here, there cannot be anything contrary to the undertaking.
Yes.
Contrary to the order passed. No, all the
Simple
rights
as
are
that.
already.
Let him simply
He has
delete this
exhausted
last.
all the no, like.
Also to claim such rights as would be available to.
No, problem is
court.
advocates drafting. Always that case.
The advocates can always advise also not to add this extra,
my
because
lord,
when Supreme Court said something, we say we will also exhaust some other remedies available.
Even assuming that he said so, can that be implemented?
No, that
assuming, my lord, that it is so, it will lead to several hearings for again.
But I'll clarify. I'll clarify.
In fact, your lordships may kindly see, my lord, that is not put, my lord, with any freak sense. Your lordship sees, my lord, for a moment, page number 36, the Honorable Supreme Court's order. My lord, what the
That
Honorable
trial
Supreme
court
Court
read
has
it again
one
and trial
minute,
court
one
understood one way.
one minute, my brother may kindly just, Lord, bear with me. Your lordship sees page number 36, my lord. No, 36. Paragraph number 2, my lord, it is the right saved in my favor. It is also informed that the petitioner suit for specific performance bearing OS number so and so is pending consideration before the trial court. We make it clear that the dismissal of these special leave petitions shall not affect the merits of this suit. Either way, the suit shall be decided on its own merits based upon the evidence. Tomorrow, my lord, if I am able to, if the suit is decreed, my lord, I get the entire property. That is the precise reason we have put it, not otherwise. My lord, so far as, my lord, my rights as of now, it has frozen to the extent that the first appeal court, my lord, has slapped a judgment against me. I have to comply that. I have, my lord, put that particular line because tomorrow if a specific performance suit is decreed in my favor, I am entitled for the entire property.
So this one,
Where is the impugned order?
The impugned order, your lordship should kindly see at page number, my lord, 33.
Please come. The petition is before this court. Agreed with the orders passed in execution number 147 of 2026 dated 22/8/2026 by so and so. Whereby the court has directed the office to issue the delivery warrant and directed the concerned police to deliver the decree scheduled property in OS number 3840 of 2018, bearing K number 40 measuring to 23,738 square feet, situated at Siddhaya Road, Bangalore. This matter came up before the court yesterday, and this court has passed the following order. Extract that order. Pursuant to the order passed by the court, the undertaking affidavit is filed before the Honorable Apex Court, and copy of it is placed before this court. Exact this undertaking affidavit, para 1 and 2. So and so. In the light of the undertaking file, the order passed by the order impugned, there shall be stay of operation of the order. When do you want?
Next week, my lords.
List this matter on 10th of September.
Greatly obliged. Then next
10th
week.
of September, because you have 30th time, that's why 10th.
Please, one.
There could be one more reason, my lord, why I mentioned that. What if, my lord, some good senses prevail upon them and they come and say, please continue the lease?
Correct,
I am
because
quite
20
optimistic.
crores is already pending due. So the great sense will prevail upon us and we'll say we will excuse everything. We will why of 20 crores and continue.
They have raised the entire theatre down, my lord, to a ghost house.
Nothing wrong with the expectation.
Ghost
but one
house
sentence.
in a man.
I wish to be
in
very,
a
very
gap of 1 hour.
Please, because we have by landlord, our difficulty starts actually, as Honorable Supreme Court said, with the execution. With the execution, because we have been fighting this since 15 years, nothing is paid. Now, Honorable Division may say pay 20 lakhs per month. That's also not paid. It's every month.
As
becoming-
everything is
One sentence,
recorded.
your lords may kindly see. This sentence should not have been there. Now I notice it. Para 2, we maybe filed that tender or undertaking to comply with the decree of payment of mean profits dues and hand over the vacant personal property. Para 2, please, my lord.
Yes.
Shell property, the namely so and so in favor of the DHRs or any other such other entity.
But if they say hand over it to somebody else, I'll have to do it.
This sentence, no. This is mischievously added. The Supreme Court said, handed over to us. We are the judge, decree
I
holder.
have said that
Such other
only.
persons, as may be directed by whom? So this cannot be done. This
We
has
will,
out
we will, my lord, hand it over to DHR only.
that your lords may mention it. Otherwise,
We will, my lord, comply the order in favor of the DHR.
The order of the Honorable Apex Court is to hand over the person to the DHR.
Will be
Hence,
complied.
the question of stating in the undertaking affidavit that they will hand over the position in favor of the DHR or such other person or entity, or shall be directed on or before 30th September 2026 is not appropriate, and counsel representing the counsel for the petitioner submits that they will be handing over the property to the decree holder.
decree holder. Decree.
10th.
Please. Decree holders. Many are there. Decree holders.
Holders.
Please, decree. Right, my lords. No. Sometimes the honorable bench may feel, my lords, why we are on the simple sentence, because For one comma or sentence, we have suffered the litigation for prolonging for 2 or 3 more years. We don't want. And I'm very sure my Lord Philip will now cooperate. The expectation is nothing wrong on my part, my lords.
Reading just not between the lines, reading between above, below, 100 feet below. My lord, I'm so grateful. Please.
Grateful. my lord.
Serial number?
Plus, in this matter, my lords, the trial court has just said, issue of court fee will be decided after framing of issues. If my lords have to kindly see
See, what is this?
page 40, my lord.
What is, where is the impugned order?
Plus page 40. Orders on valuation slip.
Give the order sheet.
And
When was the stay granted?
plus stay was granted on,
Then we'll decide this. We'll stay the operation of this order. Why should the proceedings be stayed?
let the proceedings go
My
on.
lord,
The
my,
operation of this order.
yes, my senior is stuck in the CIT court, my lord. They have just informed the matter will be taken up to 2:30.
No, I'm not. What you want is, you're aggrieved by a particular order.
Yes, my lord.
That operation of that order will stay. But why should the suit be stayed?
Plus the Supreme,
Suit,
the full court has already held in our favor, my lords, the full court. The issue of section 11 shall be decided only after leading evidence.
My lord.
May
We
I
have
pass on that?
we have engaged senior counsel, my lord. He's also out of session today.
no, I'm
Kindly
not
adjourn.
doing anything. Your order is there, that will be there.
Yes, my lord.
Only I am not, the earlier order was staying all further proceedings in
My
the
lord.
suit. So we will stay the operation of this impugned order
Yes, my lord.
and stay that with the, whatever other proceedings that may go on.
My lord.
The petitioner is agreed with the order.
Kindly pass on, my lord. I will, I'm senior and
Even if your senior comes, that I'll pass the same order. For your satisfaction, call him,
Yes,
but
ma'am.
I'm going to pass the same order.
yes, my lord.
May I pass on the full court judgment, my lords?
Because I'm not going into the merits of the
Much-
matter now.
Much.
Yes. Continue. Continue the list.
My lord, on the previous occasion, in fact, Mr. Shyam Sundar is briefed in this matter, but I'll commence the arguments. My lord, so far as last hearing is concerned, I had filed a memo of citation, my lord. This court had asked me, so far as 6 rule 2, order 6 is concerned, please provide any judgment to highlight the fact that material facts are necessary grounds for rejection of plaint to be allowed.
Suppression of material facts.
Yes.
How it will be determined?
My lord, I have filed a judgment, my lord, of this honorable court.
No, I'm asking how the court will find out about the suppression of material facts at the stage of order 7 rule 11. For that, what is the suppression? The court has to look at your written statement.
No, my lord. Here, the only issue here,
Forget about your case.
I
Any of the case, you say that there is a material suppression of fact that according to that any plaintiff will not say that you have to say from your written statement or any other document.
I'm sorry.
Yes.
My lord, the last time, the only question, my lord, that fell from your lordship is whether order 6, my lord, the argument which we did. Now, order 6, my lord, contemplates certain strict mandatory formalities to be done at the time of presenting the client. Our case precisely was, these were imminent matters to be pleaded, which was not done. Learned judge would take note of that, but would simply say, because the last application is dismissed, I'm going to dismiss. Your lordship asked me a position of law, if there is any, that says non-compliance of order 6, the strictness of order 6, would it lead to exercise of powers under 7 rule 11? Well, this is a direct, our High Court judgment, my lord. It's already given, your lordships may kindly have it. His Lordship Justice Hemant Gowder's judgment. My lords may kindly have, my lord, the judgment of His Lordship Justice Hemant Chandan Gowda. My lord, in which, my lords may kindly have paragraph number 12. My lord, paragraph number 12 is extraction of Arivandandam, It's a very famous case on about, my lord, the skillful drafting, etc. Then paragraph number 13, my lord. Order 6 rule 2, and my lord, in this case it was order 6 rule 2, my lord, we took some other, my lord, order 6 has several compartments. 6 rule 6 was our pleading, but my lord, this is on 6 rule 2. Order 6 rule 2(1) CPC clearly stipulates that the pleading should contain the material facts.
Where are you reading? Para number?
I am reading at, my lord, paragraph number 13, which is at, my lord, my lord, the internal page number 8 of the judgment. Paragraph number 13, my lord. Just before, above that, my lord, paragraph number 12 extracts Arivandandam. Then paragraph 13, order 6 rule 2, CPC clearly stipulates that the pleading should contain material facts. The apex court in case of Sopan Sukhdev Sebel has held that omission of a single material fact leads to an incomplete cause of action and the statement of plaintiff becomes bad. 7 Rule 11 of the Code of Civil Procedure lays down an independent remedy made available to the defendant to challenge the maintainability of the suit itself, irrespective of his right to contest the same on merits.
What I asked him on the other day
Yes.
was, you filed an application seeking rejection of the plaint.
Yes.
Now you have to demonstrate from the plaint amendments and the documents that it will fall under any of the clauses
Yes,
under
we
Order
did.
7, Rule 11.
Yes.
Now to say that there is suppression of fact, you are trying to rely upon your written statement or.
No, my lord, no, I am not relying.
On your grounds that are.
No, my lord, your lordships may kindly see the order impugned, my lord. I have not, my lord, relied upon anything of mine. Kindly, my lord, look at this. My lord, your lordships may kindly have page number 83. Kindly, my lord, see the last two lines, my lord, page number 83.
This is your application.
My lord, this is the order impugned. Order impugned extracts what exactly I pleaded. Your lordship sees, my lord, page number 83, internal page number 8 of, my lord, the order of the trial court. My lord, last two lines, my lord. It is argued that as per order 6 of CPC.
No, we'll go to your IA. Where is that IA?
My lord, my IA, your lordship should kindly have it at page number 86. The affidavit, my lord, is at page number 87.
Para 3.
Para 3. However, I submit that the plaintiffs have suppressed material facts and misrepresented the true state of affairs regarding the title of the ownership of the scheduled properties. The defendants number 1 to 4 do not possess a clear marketable. My lord, your lordships may kindly ignore it. My lord, I pleaded, my lord, by an overflow. Your lordships may kindly ignore it. Now, please see, my lord, paragraph 4. Before delving into the factual aspects of this case, it is essential to emphasize that 7 Rule 11 of the code, it is a procedural mechanism. The court, while considering an application of the 7 Rule 11, must give a meaningful reading to the plaintiff to determine where is manifestly vexatious or meritless or sense of not disclosing a clear right to sue. Well, this is what I pleaded. And the learned judge, my lord, understands my argument correctly. My lord, I have no issues with learned judge not understanding my arguments. Now, your lordships may kindly see.
Ultimately, under which provision? Give Order 7 Rule 11. Under which provision according to.
7 Rule 11D, my lord. Because.
There is no cause of action.
Well, even cause of action could be cause of action, my lord. Cause of action comes when there is right to sue, my lord. Cause of action comes when there is right to
Precisely,
sue.
that's what your case.
Yes, yes. Two on my lord, on two premise, A and D. Now, my lord, now I would bring my case into A to show that to have a suit for specific performance to be presented.
Disclose a cause of action.
It does not disclose the cause of action because
statement in the plaint to be barred by any law.
Yes. Now, A and D, my lord. Why A means?
No, anyhow, you can't. D, as far as D is concerned, to look at D, we have to look at your abaments in this
Yes.
application.
Now, your lordship
So we
may kindly
can't
ignore
consider
that.
D.
My lord, I'll give a
A.
go by to D. Now, my lord, A comes unless and until you demonstrate that you have complied.
No, for looking at it, we have to look at the plaint.
Yes, my lord. Your lordship sees, my lord, the plaint for a moment. My lord, I have produced what they amended it as amended plaint. Kindly, my lord, have page number 128. My lord, the the array of parties is huge. Your Lordship sees, my Lord, page number 147, 147. Paragraph number 3, my Lord, is the survey numbers, which I said, my Lord, about more than 400 acres in Devanhalli.
Oh, this is the case.
This is the case. More than 400 acres in Devanhalli for a song. And your Lordship make, my Lord, I am not trying to, my Lord,
Pass a
deviate.
judgment and decree directing
After
the-
this, they file one more suit for the same agreement that they have suppressed.
Now, please come to the cause of action.
Yes,
What
your
they are
Lordship sees,
pleading.
my Lord. My Lord, the cause of action is, kindly see, my Lord, paragraph number 10, my Lord, at page number 150 for a moment. My Lord, these are all how they acquired, etc., etc. I am not going to, my Lord, trouble your Lordships on that. And paragraph number 13, they say 400 acres, they paid 3 lakhs advance sale consideration. Fine.
12 crores is 3
One
lakhs.
second, sir. I will not interrupt you when you are arguing, my brother. Your Lordship sees paragraph number 22 is the cause of action.
How many are the defendants?
My Lord, in this, there are 140 defendants, and
With each one, they have one agreement.
no, my Lord, there are so many of them, they got impleaded and they went on amending. My Lord, they got impleaded because there are other people, my Lord, who have got, my Lord, this is a huge area, and they enter into agreement only with few. Now, what they have done to overcome this, because so many got impleaded, which they were not expecting it to be, they file one more suit for the same sale agreement, same plaintiffs, and they get that suit stayed by this honorable court.
No. What I'm trying to understand is, they have they are seeking for specific performance in respect of 400 acres.
In respect of
with whom this person has an agreement, with how many people?
My Lord, now they claim to be having an agreement.
Defendant number 1 to 4.
Defendant number 1 to 4.
Defendant number 5 to minutes.
Defendant number 1 to 4 are the owners of the property.
No, they are not. They don't even say how they got the ownership. My Lord, now thereafter, my Lord, spree of applications comes to be filed. Because no, they are not the owners, we are the owners, etc., etc. They have no issues, my Lord, in amending the plaint, going on, adding the parties. After having added the parties, now, my Lord, this is what the fulcrum of my argument. You came to this honorable court seeking specific performance decree against 4. Now look at the number of defendants who have been added. Now to maintain the suit, first you will have to cross over the rights.
They are added because they are purchasers.
Yes. Now unless you cross over the rights of the others, you still can't maintain your prayer for specific performance. The learned court, my Lord, would allow.
Ask for cancellation of the
No, nothing. Your Lordship, the prayer remains the same. Your Lordship sees, my Lord. None of the rights of the other, my Lord, impleaded applicants, impleaded defendants are sought to be, my Lord, dealt. Your Lordship sees page number 156.
To appear on behalf of whom?
I appear on behalf of 5 to 16.
5 to 16 are the original defendants or?
No, impleaded defendants. And please see, my Lord, page number 156, prayer A. Even after amendment, my Lord, they want to retain this, my Lord, prayer as it is. To pass a judgment and decree directing the defendants to execute the sale deed. No, my Lord, I am not even in agreement. It's not even a defendant in particular. They want, my Lord, all the defendants. This is how, my Lord, they use the my Lord, drafting language. To pass a judgment and decree directing the defendants to execute the sale deed in favor of the plaintiff. Which defendant now? That's also not there. Where is the cause of action against the other defendants when seemingly there are more than 160 defendants as of today? My Lord, this suit wants to be entertained. My Lord, all that I am saying is this. If your plaint is rejected under 7 Rule 11, if you want to file a better relief.
When impleaded?
Lord?
When you were impleaded?
In 2012. Earlier, my Lord, we made an attempt. And kindly, my Lord, appreciate this. Because now there are so many defendants.
From 2012 till now, he can't even seek for cancellation or amendment.
Yes, and now your Lordships would kindly appreciate one more, my Lord, fact. Because, my Lord, so many parties got implicated in that, they understood, oh, now this suit is not going to reach the shores. What they do is, please see, my Lord, same sale agreement, same parties file one more suit and seek the court's indulgence, same without disclosing the earlier suit. My Lord, I would understand on the same sale agreement, alleged sale agreement, file one more suit. When, my Lord, the entry of other defendants started in that suit, they come to this honorable court. file a writ petition, get their own suit stayed. But this is nothing but a classic case of fraud.
Yes.
That's,
Please what you say.
that's one submission. Let's kindly have a look at minutes, page number 124 minutes.
124.
120. Sorry, 241 minutes. Before going to minutes, merits of the case minutes, I would like to take minutes, the 2 points minutes, page number 241 minutes. Let's earlier minutes, the defendant's minutes, the IA number 17, the orders came to be passed by the very same court, and IA number 17. Minutes, the defendant number 5 and 6, the present minutes are the present petitioners have made similar application. That application is came to be rejected in the year minutes and 2012 minutes.
Is it? Successive applications can be filed.
Successive application is by,
Not by the same defendants.
No, it's
In the
five.
second,
You said 5,
in the
finish
only
my-
earlier application was filed
5 and 16.
only by 5 and 16.
Now,
The subsequent application is filed 5 to 16, all of them. All of them. No, my lord, my lord, there is no, my lord, hard and fast rule that second 711 can't be filed. No, my lord, I'll substantiate, man. Your lordships may kindly delete the entitlement of, my lord, earlier applicants to seek further dismissal. But I'll go out. Even otherwise, my lord, it's maintainable. Because, my lord, any defendant, my lord, has a right to file 711.
yes, correct. That's this.
No, my lord, in fact, my lord, we told it. My lord, we did not suppress it. We said, and the learned judge observed it in the order. Our beginning of the argument was that, please don't go by the earlier grounds. Earlier grounds, some of the defendants took some grounds. This honorable court dismissed the 711. Fine. Now, please look at this. In spite of this being the present state.
that a writ petition is filed
No,
against rejection of order
no,
7.
minutes, the order has not been questioned.
No, that order reached finality. And we only said, look at the present size of the defendants, present crowd of the defendants. How is it a specific performance decree be passed against other defendants or all the defendants unless and until there are prayers against them, unless and until the suit crosses over their rights, crystallizes only against, my lord, the originally impleaded defendants? Nothing is said. Where's the cause of action? No, my lord, my humble submission is this. 7 Rule 13, my lord, clearly provides them to come back to the court with a fresh plaint. Because, my lord, dismissal of 711, rejection of plaint, my lord, 711 does not preclude. 7 Rule 13 is very, very clear. If you want to come, if you still think that you have a great right based on that particular agreement, challenge my deeds, challenge all other defendants' deeds, overcome all the legal obstacles whatsoever you will have, and crystallize your rights. Not, my lord, at this stage.
Yes, that's one submission. Let him finish. The 2 points, 3 points, minutes, I would like to translate it before this honorable court. Point number 1, minutes, whether the petitioners approach the court with the clean hands or not. 1 point, minutes. Second aspect, minutes, whether successive application can be maintainable in the very same suit at a different stage. Point number 2. Point number 3 is, minutes, the defend number, the earlier, the IA number 88, the defend number 116 to 123, which has been filed with a similar application at 7 to 11, with respect to very same property. The application which came to be rejected in India 2000, 19, even that order remains unchallenged. It's reached finality. Successive application, 3 defendants has been filed, and point number 4 is, the suit is one for specific performance of the contract. I have been sued, I have a suit against the only defendant number 1 to 4, there being the agreement holders of this suit. The defendant number 5 to those who are the parties to this suit. The defendant number 126, they're the landowners. The land in question was they're claiming through 1960 title 1960 1960 the land in question was vested with the government of Mysore. The land in question was granted in the year 1963. I have been extracted in my pleadings, para number 17 of my pleadings. That has been considered by the trial court in all the successive applications. None of the orders has been passed by the trial court. Have been questioned before this honorable court. Now, after rejecting the application, the successive application is came to be filed by the very same defendant number 516 with the same footing. There was no defense has been set up in the present application. And they have been suppressed the facts which has been earlier, the application which has been rejected by the the trial court minutes. Let's kindly have a look at minutes, page number 21 minutes, 241 minutes for a kind moment. 243 minutes. I would like to take as para number 3. The plaintiffs have also filed a detailed objection to the IA number 17 and 21 to 2013, like a defense number 5 and 16. The plaintiffs have also contended that about the many things in their objection, but those averments not relevant to the consider as about the application in brief. And I also contended that they are aware of the cause of action to file a suit of thereof. They have also pried a dismissal of this IA number so and so. I would like to take minutes as relevant portion of the para number internal page number minutes 246 and page number 9 para number 9 minutes. Para number lordship is granted. IA number 70 filed under section 7 rule 11 CPCT ground that the urged in the affidavit of the defendant number 16 or there is no cause of action to file a suit. The above mentioned provisions clearly shows that the under 7 rule 11 11D CPC is applicable only where the plaintiff appears from the statement in the plaint to be barred by the any law. But the learned advocate who has appeared in the IA number 17.
This order we have read on the
We
last.
read out, and Mullers, I would like to take Mullers para number 11 Mullers for a kind moment, and that about Mullers para number clear 10 also it is made it clear. You have been clearly extracted in para number Mullers 22 of the plaint. It's made it clear about the cause of action. And Mullers, I would like to read out on the para number 10 Mullers. I don't want to go with the trouble with these things. Be that as it may, the plaint averments made para number 22. This is important. Specifically shows that the plaintiff has pleaded about the arising cause of action on 14/9/2019 and 22/9/2019 on the date of entering the sale agreement by the defendant and execution of general power of attorney dated on 16/9/2009 by the defendant number 2. The suit is filed in respect of the two items of the scheduled property. The item number 1 is having the many extents of the agricultural lands which is applicable applicants of the IA number 17 are claiming owners of the only an extent of 13 acres 28 guntas minutes. Whether partial rejection of plaint can be maintained in the IA plan. They are seeking only in lieu of this honorable court to seeking a rejection of plaint or claim which is claimed by the plaintiffs of petitioners before this honorable court in respect of 13 acres 28 guntas. Since it is generally known that the order of the rejection of plaint, court has to look into the only the averments made in the plaint and the plaintiff documents as thereof. The considering the plaint averments and the documents of the plaintiff, it is suit there is sufficient to cause of action for plaintiff to file above suit. Para number 11. This is important. It is not outside of the face of the mention that on the 9/7/11/2009 during the tenure of my predecessor in the office, defendant number 116 to 123 have filed application IA number 88 dated on 28/2018 rejection of plaint and the said application was dismissed on merits. And my predecessor officers thereof it is open to the contesting defendants to challenge the said order dated on 7/11/2019 by the filing a necessary appeal or petition as may with me. But instead of the doing so, the defendants have filed above suit for filing similar application on a cause of action for a delay of disposal of the IA number disposal of this suit in the year 2020 world case. Therefore, in the view of this in the angle of this one, this application was rejected on cost minutes.
Yes.
See, suppressing of all these aspects, now he has come up with the successive application in the same ground. Same ground. Whether Mullers, before going to that Mullers, I would like to take Mullers page number annexure Mullers C1 Mullers sale deeds. 3 different sale deeds in respect of the different dimensions. Page number 174 Mullers. The time to copy it is in the Kannada version.
Each sale deed is 100 acres.
No. In fact, the same sale deeds has been purchased in the same day. The only point is the plaintiff's vendor was not success. They are claiming a right through 1960. It's a purely question of fact. Fact cannot be decided by these things on the basis of the mini trial cannot be held at this stage of the suit. And post aspect. And second aspect is 1960 the land in question was seized by the government of Mysore.
Into all those issues. All they said it doesn't disclose the cause of action.
We have the
that you have submitted. So only to do that. I mean, I'm not going into the merits of the matter.
Great. And other aspects, I would like to take on judgment of apex court with regarding to successive application can be maintainable in the different stage of the suit is important.
Paragraph.
I would like to take page number para number 35. Before going to that, my lords, I would like to take my lords, para number 3.
This is the latest judgment of the Honorable Supreme Court, my lord, on
Let me finish,
earlier
sir.
the position
Let
of
me
law
finish.
was read. Which
Let me
position of
finish.
law?
Let it be, sir.
I am conceding
Of
with
course,
the
my lords.
judgment. I am
Of course,
conceding.
he is a senior counsel. You don't want to my lords, attacking on me, my lords, as a
No,
junior.
no, I am conceding for your judgment. I am conceding. Can I differ with the judgment of the Honorable
See,
Supreme
all the
Court?
while is interfering my submissions.
The
whenever I
latest
supposed to be
position
fair
of the
about this
Honorable
court.
Supreme Court is that, my lord, earlier, your lordships, my lord, are kindly aware, my lord, order 7 to 11 did not, my lord, invite the rigor of res judicata because, my lord, there is no fact decided. Now the Honorable Supreme Court has held res judicata would be applicable if the same facts are dealt with earlier. That's the rider.
I would like to must take my lords, para number 35. my lords.
No, I'll go through this.
That's the only, I just pointed out was 2
Yes, you
points.
can
my
tell
lords.
what is the ratio laid down. I'll go through that.
Only, I just, my lords, 7 to 11 application cannot be maintained with the suit, stages of the suit. And my lords, it is clearly mentioned, the earlier application is retained, my lords, attains the finality of the same, my lords. That before, my lords, IIA number 2 IAS has been, 3 IAS has been decided by the very same court. That orders has not been questioned before this honorable court, my lords. And at this stage, my lords, the application which has been filed by my lords has not been made. And the, my lords, whatever my learned senior counsel is pointing out, my lords, at 6 rule 6, there is no cause of action. My lords, I have been specifically, my lords, extracted in para number 22. It has been considered by the, my lords, the court below. And my lords, the trial court order is para number 9, 10, 11. It's made it clear. There is a perversity to Malas order has been passed by the trial court in order to Malas called for interference of the order. And it is specifically mentioned in the Malas the latest judgment of this order. Para number 71, it is made it clear. That's earlier Malas this application has been considered by the very same.
You said para 34?
Para number 35 and 39. I would just point it once.
34 and, no, don't have to read. Para 35 and?
Para 35 and 38. 39 and para number 71, my lords. 70 and 71. 70 and 71. It's made it clear, my lords. The application cannot be maintainable in the, my lords.
Yes, next.
Greatly obliged.
Grateful.
My lords, I'm appearing for the petitioners, my lords.
Posted Shara, notice to R2
My lords,
as unclaimed amounts to deemed service of notice. Yes.
my lords, we have served the notice on the counsel for R1 and R2 in the trial court, my lords. The memo has been posted yesterday, my lords.
You appear for whom?
Petitioners, my lords.
You served on whom?
R1 and R2, my lords.
R2 is already served. And who appears for this? Mr. Shauri HR appear for whom?
R1, my lords.
Give the file. Yes, both R1 and R2 are served. Look at it, interim order is there. No representation on behalf of the respondents. Interim order earlier granted is extended. Yes, 65. Even in 64.1 also, R1, notice to R1 is held sufficient. Yes, next. 5.
Take notice for all the respondents.
AGA takes notice on behalf of all the respondents, notice on all respondents.
All respondents.
This is matter on 6th of October. Yes. No representation in the month of September. Yes, 67.
Served a copy. He is
I'll be filing my power today, my lords. Any date next week if it may be taken up.
Should be on Monday, my lord. The reason
Yes,
is.
Monday.
Please.
Yes, next.
Obliged.
So and so as submits that she has instructions to file wakalat on behalf of respondent. Only sole respondent. Sole respondent. Yes.
I am for the.
Monday. Yes, 68.
And for the petitioner, I've served on all the respondents and acknowledged also placed there. Now the matter is, the pleading service is completed, my lord, so that it can be
No,
disposed.
no, that we have to record it.
Please.
A memo is filed stating that the notice the notice is served on the council appealing with the respondents R4, 6 and R9 and 10. Memo is taken on record and notice to respondent held sufficient. List the matter on 7th of September.
7th September. 7th.
Yes.
Can you direct the office to show my name for R1 to R6 minute? Today I have filed the
So
Vakalatnama.
and so,
Please.
office is directed to show the name of so and so. Yes, next.
My lord, I appear for petitioning in this matter, my lord. My lord, identical matters are reserved for the orders before a division bench at Dharwad, my lord.
May I make a submission?
My lord.
This only dispute regarding 15%. I wanted for 9%.
Already they have excess amount they have already released, my lord. On that basis we have
When is
came.
it coming up before the
My lord, they have not yet mentioned the date.
matter?
Please, my lord.
List this matter on 10th of September.
May I make
Please,
a
ma'am.
submission? So far 9% is concerned, there not, at least I may withdraw that much of amount. my lord.
Already excess amount has been withdrawn, my lord.
The
Subject to
affected
outcome
lot
of that appeal, I request kindly adjourn the matter, ma'am.
Yes.
Much obliged.
Appear for petitioner lordship. Lordship, in this case, last time when the matter was came for the first time, your lordship, notice was issued, your lordship, but same is not reflected. I've even paid the process, your lordship. It was on maintainability, your lordship. It was on maintainability. The order was kept in suspense, your lord.
What
I'm not challenging any order, your lordship, here. Just I'm seeking direction to speedy disposal of my application, your lordship. Annexure, lordship, page number 20, your lordship, order. Order on I number 2, your lordship.
You say that to set aside the order dated 6/6/2026. That's a prayer you're seeking. And also a
And-
mandamus.
Lordship, and the prayer B, your lordship, issue writ of mandamus.
Not insisting for prayer A.
No, I'm prayer B also, your lordship. That
It can't be. You want prayer A or prayer B?
it lordship may be directed to,
Prayer A, office has raised objection with regard to maintainability.
please, lordship. Prayer B may be considered and passed, lordship.
So you're not insisting for prayer A.
That may be set aside, your lordship. This.
It may be set aside.
No, lordship. I'm not insisting, your lordship. That may be, that may be disposed of.
Now, why should be a mandamus for a 2024 writ petition?
Lordship, because, your lordship, may.
Order 7 Rule 11 application
Lordship.
filed in 2024.
That was kept in abeyance, your lordship.
Why?
If the court was heard, your lordship, by both the parties, your lord. I'll kindly take to, lordship, kindly come to page number 20, your lordship. Para number 3, your lordship. The present suit is filed by the plaintiff against the defendant seeking partition in respect of suit scheduled properties. The defendant has stated that the suit is barred by law of limitation.
Where are you reading?
Page number 20, your lordship. Page number 20. Order shoot, your lordship.
No, you're saying that hence the present application, the present suit is filed with the plaintiff defendant seeking partition. So the suit is barred by law.
Hence the present
This
application
expression
kept
of
in
fact and
abeyance,
law
your
which have
lordship.
decided evidence of parties is required. Application is kept in abeyance.
Please, lordship. I'm seeking direction, your lordship, to dispose of the application.
The writ petition is filed seeking the following prayer. Learn counsel for the petition submits that he is not insisting on prayer number A. As far as prayer number B is concerned, the court has to pass, it is submitted that if the application is not maintainable, court has to consider and pass orders, and it can't keep the application in abeyance. Considering the submission, this court is passing the following order. The writ petition is disposed of, directing the court to consider the application filed under Order 7 Rule 11 CBC in accordance with law.
In time,
As
time limit-
expeditiously as possible.
Time
Yes.
limit may be fixed, your lordship.
Yes, next.
My lady, I appear for petitioner in item 71. My
Yes.
lady, we're seeking a short adjournment if possible, my lady. The council is not available today due to some personal difficulties.
Yes, list on 9th of September.
My
To
lady,
take it in.
if a time can be fixed for the matter.
What is that?
My lady, if a time may be fixed.
At what
Or
time
if-
you want? 12 o'clock, 1 o'clock?
My lady, 2:30 is convenient.
Call the next matter.
It's respondent number 1 and 2, my lord.
List after service of notice to 3 and 4. Yes.
The 3 and 4 are not represented by, before the trial court also, they are not
73.
72. That can be dispensed with, my lord, because that for
But they have to
2014
ask.
suit, my lord.
That the petitioner has to ask.
No, but petitioner has to say, but they are not
Any
ready to.
interim order in this?
Interim order is there. That is the reason they are enjoying the benefit of the order, my lord. But the one,
Representation on behalf
3
of
and
the.
4 are the none other than the
Representation on
daughter of
behalf
the
of
one
the
and.
petitioner.
Fill for petitioner, my lord.
What are you doing when the matter is called?
Proxy counsel.
The list is matter on Saturday. Interim order earlier granted is extended till then. It is made clear that on that day, the land counsel of the petitioner shall address arguments on the merits of the matter.
Please, my lord.
Yes.
Petition. I think R1 is so, my lord. With respect to other respondent, I'll file memo for dispensation because they are not the contesting defendants, my lord. Respondents, my lord.
Which respondents?
Respondent number 2 to 5, my lord.
Yes, memo is filed second dispensation of notice to 2 to 5. Memo is taken on record and yes, interim order is there.
Interim order is there, my lord.
Yes, extended next week. I mean, list on 22nd. Yes, 74.
My lord, I filed a memo with the receipt of service of hand summons, my lord. There is a direction. Today I filed a memo with receipt of service of hand summons, my lord. There is a direction to serve the hand summons to the trial court advocate. In that regard, I filed a memo, my lord.
It says a memo has not been filed.
Today I filed morning filed, my lord.
Yes, this is matter on 18th of September.
Office, my lord, has raised an objection
Hmm.
stating, my lord, that 2 writ petitions are to be filed. My lord, may kindly look into Annexure A, my lord, at ink page 35. The order, my lord, is at operative portion of the order, my lord, is at ink page 55.
Yes.
There were 2, my lord, miscellaneous petitions that were filed. Questioning, my lord, the orders passed by the trial court, rejecting the application of the plaintiff under order 39 rule 1 and 2, and allowing, my lord, my application under order 39 rule 4. Now, my lord, the first appellate court has passed a common order.
But that can't be in one
Lord,
petition row.
Orders, my lord, are common. Facts, my lord, relate to, my lord, one particular substance of the case.
Office objection is sustained. The petitioner shall come up.
Lord, may kindly have it on Monday, my lord. I'll file another writ petition also.
Yes.
Let this writ petition may be taken up on Monday, my lord.
Yes, Monday.
Monday.
Call the no further matters. Call the passwords. Any 2 mentioned matters.
Serial number 77. 77.
Yes.
My lordship, kindly the matter may be had on Monday, my lordship. We have engaged the senior counsel. Hence, I pray that on Monday it may be
I'll
taken.
clarify the order and then let your senior counsel come.
My lordship, on Monday it may be taken, my lordship.
The petitioner
My lordship, here.
is agreed, has come before the court, questioning an order. Where is that page number?
Page number 40, my lords, 13 to 2026. On a court fee issue.
Is before this court, questioning an order on valuation.
My lordship, 2 findings have been given on the same application, my lordship.
That's why
One
we'll-
is at page number
We'll stay the operation of
35.
that order.
My lordship, one is on 35 and another is on 40.
I am not deciding this application.
Yes, my lordship.
Please wait. If you hear the order, you'll understand. Order on valuation of the slip dated 13 to 2026. A coordinate bench of this court on 8/4/2026 has stayed all further proceedings in OS number 25314 of 2024. Land counsel for the petitioner submits that in view of the stay granted on this, even the petitioner's application for injunction was not considered by the court. There are stay of all further proceeding, considering the submission of the land counsel for the respondent and balancing the interest of both the parties. The operation of the order dated so and so is state. This matter.
It may be clarified that further proceedings.
The other proceedings may go on.
My lordship, when the application is filed on the maintainability of the suit, my lordship, how can it be proceeded, my
Maintainable, what is
lordship?
that maintainability of suit?
Because, my lordship, there is no sufficient court fee has been paid. Other CRP also is filed, my lordship.
Decided by the court that.
It's not maintainable at all, my lordship,
That is what
because when it is
exactly the
not
full court-
maintainable.
That
If you
is what
want,
ex-
argue, give
That is
that.
what exactly the
Yes,
full
please
court has
argue
said.
the matter.
Is not at all maintainable, my lordship.
Argue,
Under order
argue the matter.
711A, my lordship.
Yes.
It will have to be decided after.
A to D. A to D has been challenged, my lordship.
Yes.
CRP 16 of.
Argue.
My lordship, my lordship, on Monday it may be taken, my senior designated counsel will be coming, my lordship, because we have already engaged. On submission, my lordship. My humble submission and request, my lordship. Because we have
Only
handed over
subject
the
to
file
valuation of
also.
it. Earlier order holds good, the same order, what I have said. Yes, next. Huh? Yes. Any other 230 matters? Huh? Yes, call
This
the.
order has now been clarified, Milord. The
Yes,
order
sir,
is
clarified.
much-
Other proceedings may go on, the same order, yes. When it was mentioned,
Yesterday I had mentioned it for today's board. It has been posted. It's serial number 77. The urgency is this, my lord. If I may.
what is urgency?
My lord, the executing court, my lord, has issued attachment of movable order, my lord. Today it was posted before the executing court.
When was
Today,
that order passed?
my lord, that order has been passed last week. Today, the executing court, my lord, today was the matter listed before the court below. It has passed one more order under order 21 rule 35 without calling for objections from the JDR also. Passed the order for breaking open the lock of the suit schedule premises, my lord. I'm yet to receive that order, my lord. Today afternoon it has been.
Anyhow,
passed.
whatever is the order now, that only we can see. We can't
Please, please.
anticipate on something what the court
No,
has
that is
done and
the-
we can't
my
pass
lord,
order.
today's passing of order, my lord, is not disputed by my learned friend also because.
But in spite of that, I will not pass any order without.
No,
that
I am
being
not
put to-
asking any order to be passed on that, my lord. I am just bringing to the notice of this honorable court that today one more order came to be passed and I may be permitted to agitate that order also.
Yes.
And till that period, my lord, I'll file the necessary application along with the certified copy of that order. Till that period, my lord, till Monday, that order need not be precipitated is my only humble
Can
submission.
any court on this earth can pass such an order without there being an order copy, without there being anything? Just like that, some order is passed, that should not be
Not
given
just
effect
like that,
to-
my lord. The respondent herein was very much present before the executing court when the order was passed. My lord, the passing of the order for breaking open of the lock is not in dispute.
I can't pass that kind of orders.
My lord, at least, my lord, till the.
Unless the writ petition is before me, unless the impugned order is before me, I will not take anybody's, let even they accept also, but I will not pass order.
On submission, Swami. They
My
are
lord,
not- They are
my
filed
lord,
three
here-
application. They are not served also, Swami. They are not filed, served.
Yes. Pass order. Yes. No representation. This is matter in the month of October. Yes, next.
One moment, please. I will get the file. Please. Please, file, I have to get the file. Moment, please.
Which matter?
Please, file is. Just a moment.
It calls the next matter.
I have this additional document and also
50?
the plaint 59, seal number 59. The petitioner filed a application, section 92 of the CPC. That
I
petition
think
was.
last, somebody has argued this matter, if I remember.
Last
time
time it is argued.
Who
It is
appeared?
only Anand. Anand is advocate, senior counsel is M.R. Rajgopal is appeared last time. It is only for the non-production of the plaint copy. It is 148 miscellaneous petition. The matter was urgent. The everything is over, but is I have produced that is miscellaneous petition 148, Last time also it is availability, the clerk was not put up, the same is put up here, and also I produced this petition copy. That may be considered, my lord. The 148 petition copy, it is clearly said that it is not maintainable, the prayer itself is. It is page number 214.
Come to the impugned order. Where is the impugned order?
Impugned order, my lord, that is the impugned order. It is para number 14, reasons. Impugned order, page number 24, internet page number 24. Impugned order, page number 24, para number 14. In the case of the allegation made by the petitioner, is that respondent trust had amended the trust deed and removed the petitioners from the membership illegally. However, it is the contention of the respondent that they have removed the legally. To strengthen their contention, they relied upon letter dated 24/3/2025, which shows that complaint was signed by 180 members making allegation against the petitioners. Another document is dated 8/5/2025, which is the notice given to the Ganesha, Prakash, Sridhar, Govardhan, Narayanaswamy by saying that their membership is going to be suspended and as there is a misuse of their trust. Another document
The
is
permission
the
is granted under section 92 of the CPC.
My lord?
The permission granted is question.
That is question in the 92 CPC.
Yes.
It is 3 criteria is fulfilled by the petitioner. That is, it is next, the back page. That is the 3 criteria. That is the page number 20. That is the removing the trustee, appointing the trustee and wasting the any property trustee. It is 3 criteria. They prayer in itself is miscellaneous petition. They are not seeking the declared as a trustee, first point, and also not seeking the remove the trustee, because trustee established by the petitioner themselves, the properties belongs to the association. When the president is elected as a president to the association, then he was created the trust deed and also execute the lease deed himself in favor of the trust. It is not mental against the sale deed, because the sale deed is government land granted to the association. That clearly specific. I have produced this sale deed also. In this sale deed specifically said that not alienated any property in favor of the third party. They himself is association members created the trust and executed the sale agreement, that is lease agreement in favor of their.
Yes.
After the election, that association against that was not maintainable. Therefore, we have calling upon the membership and also persons that the lease deed is cancelled by the elected by the association members, and the lease deed was cancelled. The lease deed was because cancelled, that is not permissible under the law. That was questioned directly, and also removed the trust. That is, the trust is under the association. It is not independent trust. Under those are members of the association members. They are the members of the trust.
Yes.
But the trust also that is belongs to the association. Therefore, association members calling upon him, the lease deed also cancelled and removing the membership. If they are agreed, that's lease agreement executed by themselves, they have filed the original suit not under section 92 of the CPC. That is our grievance. That prayer itself is not maintainable in the petition, because para number in the petition copy, para number 4, petition copy.
Yes.
214.
Yes.
Petition, miscellaneous petition copy, para number 4.
Yes.
In the additional document.
Yes.
It is submitted that petitioner has filed the suit seeking for judgment and decree declaring that cancellation of the lease deed dated 22/9/2025 executed by the respondent number 192 registered as a document number so and so. Office of the Sub-Register Nagarbhami thereby cancelling the lease deed dated 29/3/2023 as a null and void,
and not asset document, and the same is not binding on the petitioner herein, and also for declaration of register amendment, amended trust deed dated 28/10/2025, interesting certain amendment clause C of the trust deed dated 2/12/2022, expelling, removing the petitioner 125 from the trust and nominating, appointing respondent 1234 as trust as illegal, null and void, and not binding on the petitioner, as the same is contrary to the provisions of class 2 and so dated 2/12/2022, and for consequent release of the permanent injunction against the respondents.
Yes.
This prayer is not maintainable because they have not questioning the trust.
Yes.
They have directly questioning the lease agreement. They themselves is executed.
Yes.
And also we are that purpose removing the trustees from this trust, because those are persons of the association, they are persons of the trustee. After the electing association members, because of the illegal activities made by the respondent, the lease agreement executed themselves. It is not permissible. I produced the sale deed also. That is the sale deed also produced, my lord. It is, I have produced the sale deed, and in this sale deed also it is stated that para number, page number, my lord, additional document, it is page number, sale deed.
Yes.
Sale deed, para number 36.
Yes.
The conditions laid down. Sale deed. These deed sale of made 14th date 2000 executly Governor of Karnataka, represented by Tahsildar Bangalore, North Taluka, Bangalore, herein after referred as a vendor, so and so. And Sri Bhavana Rushi Padmapitha Mahasamsthana, register number 16, 5th main, Agrahar, Dasarali, Bangalore, represented by General Secretary Srinivas Murthy, herein after called as a Vendi. Expression shall mean and include the successor of office, executor, administrator, so and so. Witness as follows. The Governor of Karnataka here be granted the land survey number 144 measuring 2 acres 35 guntas, Ullal village, Yeshwantpura Hubli, Bangalore Nalkala, east pair of the Vendi.
Why all that are relevant for
Yes,
this?
liberant portion condition is laid down in the 1, 2, 3, 4, 5 executed in the sale deed, not to alienate any property association belongs to any third party. That is the condition laid down in the association sale deed.
We are on the point.
Point one is my lord. Point one is my lord. Those are executed the lease agreement. Association members, they are the president. They themselves created the, that is trust. That is not permissible under that association.
No, that I understood.
That's
enough.
why we are removing the trustees.
Whether the permission granted by the court, leave granted under 92 is correct or not, justified or not. That's a
that is
limited
prayer.
thing. For that, you don't have to go here and there.
Three prayer, that is.
Mr. Senior Counsel. Yes, what do you say?
My basic submission is, while an inquiry is expected so far as grant of leave under section 92 by the higher courts, the scope of inquiry is very limited. Because my lord, section 92 CPC is a special nature of suit is provided. It is as against the trust. There are two conditions precedent or it has to be followed is either an advocate general has to file a suit on behalf of the trust or violation of the trust, or there must be a leave by the court. My lord, to file a suit along with miscellaneous application, my learned friend wanted to argue that he read miscellaneous petition, therefore there is no averment. No, it is not like that. Suit plaint has to be read cumulative with the miscellaneous application. If we could able to demonstrate by virtue of our pleading in the plaint, there is a breach of trust or trust deed provisions are overreached by virtue of the act of others, that is fallen within the purview of section 92 of the CPC. This is precisely the point. Now the trial court may not have taken the view. Can I read the order of the trial court for a moment? I think I'm learned judging. Just for a your lordship's reason, my lord, I will just read the order. Paragraph 14 may kindly be seen. Order dated 29th April 2026.
Yes.
Before that, may I request Lordship to go to paragraph 12.
Paragraph?
Paragraph 12.
Yes.
Lord, it is section 92 of CPC is extracted.
Yes.
Now we are claiming relief on three things, my lord. Removing of any trustee. B, appointing a new trustee. And we also sought for settling the scheme. It requires an administration by court intelligence. This is the three reliefs we sought for. But paragraph 14 of the order may kindly be seen.
Yes.
At page, paper compendium ಒಂದು ಹಾಕಿದ್ದಾರೆ 70 ಅದರೊಳಗೆ. Anyhow, paragraph 14 order.
Yes.
In this case, the allegation of the petitioner is that respondent trust had amended the trust deed and removed the petitioner from the membership illegally. However, it is the contention of the respondents that they have removed legally. To strengthen their, may kindly make a note. Controversy is, according to us, they removed us unceremoniously. They said we are lawfully removed. This is a matter to be decided by the trial court in the suit. That was the principal issue. Determining factor is any one of the elements provided under section 92 is present in a suit filed by us under section 92 while seeking the leave also. A leave is sought for by way of an independent application. It is plain and the application to be read together. Then court has to gather whether any elementaries under section 92 is present, leave have to be granted. Even the Supreme Court in 1991 said it's an administrative order. Without a reason also leave could be granted. I can cite the judgment. Then to strengthen their contention, they relied upon the letter dated so-and-so, which shows that complaint was signed by 180 members, making allegation against the petitioners another under document so-and-so, which is the notice given to so-and-so, and by saying that membership in going to suspended that there is a misuse of trust. Another document is the letter written to the chairman regarding amendment to the trust deed issued by the Ganesh dated so-and-so. Another notice was sent to the petitioners. The cancellation of the lease deed is also produced, proceedings, etc. Then para 15. In this case, on perusal of the materials, may kindly make a note, Miru. Available on record, even though respondents have produced the notice regarding intimation towards termination of the lease. These aspects have to be decided before the court. There is a mistake crept in that without disposing of the petition, suit came to be registered. However, there is direction by the Honorable High Court of Karnataka to dispose of the application. But since there is a material to show these trustees were initially in the trust, now the respondents have removed them. May kindly know. From the trusteeship, whether that removal is legal or whether it is the amendment is properly done or not at all to be decided full-fledged trial. Hence, it is just necessary to give permission to as per section 92 of the CPC, since it is a public trust. Then may kindly see the plaint averment for a moment. Just two paragraphs I wanted to refer to attract the elementaries of section 92.
This is matter on Wednesday.
Yes, madam. Grateful.
Near the passwords.
My lord, the amendment trust, whatever it may be, that is
Wednesday. Yes.
Wednesday. The matter is listed for Wednesday, my lord.
Yes, yes.
Cell number 60. Cell number 60.
Respondent number 1 seeking 1 week adjournment, my lord. Senior is out of station.
Yes, this is matter on Monday.
Point of law, my lords. Barred by the point of law, my lords. On the last date, I told to serve the hand summons and come back.
Monday.
31. Cell number 61, MD Raghunath.
May I request for Tuesday, my lords, if it's not in current Tuesday, may I request?
Tuesday.
Grateful.
For petitioner in this case, my lord, I request this honorable court may kindly take this matter on Monday, my lords. Affidavit filed
On
Monday
humble
will come
submission,
to-
my
Matter on
lord.
6.
Already yesterday, affidavit has been
What is this?
filed. My lord, it is issued for ejectment, my lord. The order is in my favor. They have challenged the same.
We are
And they
filing
have,
an affidavit saying that we'll vacate the property, my lords. Today senior was supposed to come, he was there here, but due to some.
Saturday I'll take up. Saturday is the first
Thursday,
case.
Thursday first.
No, Saturday, first case.
please, my lord.
My lord, Monday, my lords, I kindly request. Monday will
My submission is affidavit may be allowed, my lord.
dispose Monday.
Saturday.
Please, my lord.
Yes.
Serial number 48. Pass
48.
over 48. Second page.
I'm sorry, Lords, I appear for the petition. I'm sorry, Lords, I was not there in the list. Lords, the fifth respondent's writ petition. The challenge is with respect to an order confirming the injunction restraining the alienation against me. Lords, in the final decree proceedings, the plaintiff was entitled to only 1/20th share in the suit schedule property, entire property. The entire property, my lords, is divided into two sub-numbers of the land in survey number 173/1 and 169 survey numbers. And my lords, both the survey numbers have the equal benefits. 1/20th share of the plaintiff works out only to 6 guntas of land in the entire land that is there, was the subject matter of the partition. I was an alienee to an extent of 3 acres of land in survey number 173/1. I got a proposal now from for setting up a petrol bunk in the one portion of the scheduled property. I made a submission to the court that I am going to earmark 5 sites formed by me in survey number 173, already formed over there by me after the purchase of the property, and permit me to develop only to a portion of the property, because the respondent who is the plaintiff before the trial court is entitled only to 1/20th share amounting to only 6 guntas of land. And total extent available for partition is around 4 acres, 32 guntas of land. She is entitled only to 6 guntas of land, and permit me to develop, because being the purchaser, even in a final decree proceedings, I am entitled to claim the benefit of the succession to the estate of participate in the partition and claim the benefit of a co-sharer. And my property that would be allotted to me is much more larger than what is that is been allotted to my share. Therefore, please kindly permit, because both the properties are of the equal importance and equal value, and it's on the either side of the Kanakpura road. And this is an opportunity given to me once in a time, and permit me to develop to an extent of 100 into 120 square feet. And my lord, that came to be rejected by both the court. And I would request this honorable court to kindly turn to page number, my lords. Reasons are there at page number 56.
What do you say?
Lords, my submission is the purchase itself is violating the interim order passed in the suit. The suit, my lords, 27/5/1991, the trial court has granted a temporary injunction in which the petitioner is also a party. A temporary injunction restraining the defendants from alienating was passed. Violating that order, my lords.
Oh, he has purchased the property in the,
No.
during the subsistence of the
Yes,
injunction order.
violating the
No,
injunction
that is
order.
not-
Lords,
No, no, I have purchased in
18/7/91.
1991.
Yes.
Even before service of summons, I have not done anything contrary to that kind of a thing. In 1991, I purchased a property pendent elite. I am not disputing that. That's what exactly is purchased by a pendent elite purchaser. But my properties, I have contesting the suit from 1991 onwards. The suit opportunity opened to me only in 2025. This is where the application came. Primary decree proceedings I participated. I have not violated any order of the court. There was no order against me on the day when I purchased the property. I'm sorry.
This order is in FDP.
It is in FDP, passed in FDP.
FDP.
And
Suit is
we were-
decreed. He has not filed any appeal against the decree.
No, during the pendency of the suit, I purchased. There's no dispute on that. But not violating any interim order of the court. That's the wrong
May
thing.
kindly see 65, page
Oh, the
60.
FTP proceedings are underway. Why should you do something now?
My lords, the property is around 4 acres, 32 guntas, and claim is only 6
Which
guntas.
property will fall to your share? What will happen?
Lord,
How
there are-
all that can be decided?
My lords, I could ask the equities be distributed in my favor. This is what only the submission is. Even whatever my vendor is entitled to, I am entitled to. That's what the position of law
That
is.
will be with regard to where now you want to establish a outlet.
Only one portion of the property, not the entire portion of the property. That is 173, 80
So
to
unless and until this final decree proceedings continue, unless a commission is appointed, the feasibility of allotment is
But my lords,
decided.
my
Where is the
entire
question of you?
development would be curtailed. My entire, for no reason, because
You're a
26
purchaser,
acres,
and you're a
26
purchaser,
years.
you're bound by whatever that happens to the other
No, my
members.
lords, 26 years I could not, no, there are other properties available to them for partition. It is not that no property is available for partition, nothing of that sort.
No.
And may kindly see the portion of the property I am intended to develop. Only an
It
extent of
can't
it.
be decided now. For you establishing a petrol pump, they will not decide that wherever you want, you can have.
No, I have only in a portion, even afterwards, my lords, there is lot of frontage left out over there in the same survey number, which is in my possession. That can be accommodated over there to them. My lords, I are required to participate by virtue of section 44 of the Transfer of Property Act in the final decree proceedings is not disputed.
You can't be made to establish your petrol bunk or make any, alter the nature of the property.
Or at least permit me to develop the way that I want by own way, subject to outcome of this litigation. Because otherwise, for no reason of mine, as a property has been sold before service of summons on me, and I will be subjected to some kind of hardship in the matter.
Dismissed.
May kind.
Yes. What happened to? It is not passed over. It is already adjourned. 44.
44 this minutes.
Huh? List it on Monday. Yes. Done? Is that, one more password is the 230 matter. One more is there. No, one is passed over. First one, 95.
Bill number 95. 95, Passover, 230 Passover.
My lord, I may be permitted to submit on behalf of petitioner's advocate. There's an application under Order 7, Rule 11, which was rejected by the commercial court.
Yes. Yes.
Yes. ma'am. Give me the writ petition.
Where is the order?
Please, madam. The order starts at page 81, madam. Reasoning is at page 94. What is this? My lord, just a little background, my lord. One of the grounds which we had taken is with reference to whether, my lord, can I just give a little background of the case, my lord?
Yes.
To see what it is. My lord, the plaintiff, please see the plaint, my lord. It's at page 35, in page 35.
Yes.
The plaintiff, my lord, he is described as son of so-and-so, age so-and-so. The first defendant is shown as an association of persons having its registered office. I'm just underlining that.
No, what is the suit for?
My lord, he files a suit to declare his share of property. The relief, my lord, is,
Where is the plaint? Let's see the plaint.
yes, my lord, ink page 35 is the plaint,
35.
35, yes. And the prayer, my lord, is at ink page 51. He claims that there's an association of persons. So his first relief is to declare that the first defendant AOP is dissolved with effect from 12/9/23. Declare that the plaintiff, this is very interesting, my lord, declare that the first defendant AOP is dissolved from 12/9/23. Therefore, if it is dissolved, could not have been a party to the proceeding. declare that the plaintiff is entitled to 38 by 100 share in the suit schedule property, direct the second, third, and fourth defendant to effect partition, division of suit schedule property by metes and bounds, and apportion plaintiff's share of so and so, decree for future mean profit, grant permanent injunction, This is the main relief. G, declare that the agreement of sale dated, that is in favor of the petitioner, entered into between the second defendant and the fifth defendant, being represented by the sixth defendant, registered in the office so and so, as null and void, and not binding on the plaintiff.
All this relief in the suit and everything appears to be, or strange reliefs.
Yes.
Yes.
And declare the agreement of sale dated so and so, not binding, only not binding on the plaintiff, not on the AOP. And then declare the agreement of sale as null and void, not binding on the plaintiff. And he also asks for declaration of the various sale deeds which are executed in my name to be declared null and void and not binding on him. My submission for my lords is,
What are the grounds of your order 7 rule 11?
yes, my lord.
Where are they? Where is your IA?
Yes, ma'am. My lord, it's at page 60. Number 2, that is, one is, it does not show a cause of action. The second aspect is that he himself claims that this association of persons was formed much prior to him becoming a member, and he became a member on 16/1/2018. And much prior to him becoming a member of the association of persons, the defendant number 2 had acquired the property in his own name.
Plaintiff became on 16/1/2018.
18.
When the properties were purchased.
In 2005. 2005. Purchase, please see item number 8. Even according to the plaintiff, as stated in para 9, the suit schedule property was purchased in the year 2005, and that is 18 years prior to filing of the instant suit. Even according to the plaintiff, from the date of acquisition of suit schedule property in the year 2005, as stated in para 9 to the suit, and up to 29/8/2018, that is when he became a member, and up to the date of filing the suit, no suit or proceeding or claim was made as against the suit schedule property by the first defendant, that is the association of persons. The first defendant, who according to the plaintiff was constituted on 2004, and until this date, that is nearly 2 decades, has never made any claims that the suit schedule property belongs to it.
No, what is the relationship between the plaintiffs and the defendants?
Yes, ma'am.
Come to the plaintiff.
Yes, ma'am. Page 35. My lord, plaintiff is the son of late Prabhakar Reddy.
1 minute.
Yes, ma'am. Page 35. The second defendant under whom I am claiming title is the plaintiff's brother-in-law.
Where is that person, Prabhakar Reddy?
My lord, he passed away in 2018. Before coming to first defendant, my lord, second defendant, Akash.
So plaintiff
First
is the
defendant-
son of Prabhakar Reddy.
Yes. Second defendant is the plaintiff's brother-in-law.
Brother-in-law.
Yes. Third defendant is the plaintiff's sister, who is the wife of the second defendant.
Second, yes.
Fourth defendant is claimed to be a partner of the first defendant. Fourth defendant, Muniswamy Reddy.
This is the association of persons.
Yes, but
Who
they,
are the members of this association of persons?
my lord, according to the plaintiff, the second defendant, third defendant, fourth defendant were the partners, and the plaintiff was admitted to the firm in the year 2018. That is the case of the plaintiff. So even according to the plaintiff, in the lifetime of his father, he was never a member of the association of persons. According to him, The son-in-law was the member of the association of persons, and the daughter was the member of the association of persons, and this Muniswamy Reddy, who is the fourth defendant, is the member of the association of persons. My lord, this entire case is an indirect way of the plaintiff trying to claim rights to a property which the association of persons has never claimed during its existence. Please see
Properties are in whose name?
defendant number 2, who in turn sold it to defendant number 7, defendant number 5, defendant number 7.
Defendant number?
5 and 7.
When did you purchase, when these two purchased the property?
23, my lord.
2023.
Yes. 2023. My lord, the entire case, my lord, of the plaintiff is constructed in this manner. It is completely inconsistent for even conducting a trial or to make out clearly what is the case of the plaintiff. My lord, one aspect I should bring to my lord's kind attention. In 2004, 2005, there was a law called this prohibition of persons buying agricultural land in Karnataka. So under section 79AB, which we call normally section 79AB of the Karnataka Land Reforms Act, only a farmer could buy agricultural land, very clearly. No firm, a firm or a company could take special permission under what is called 109 of the Land Reforms Act. If they are going to put up a school or an institution or something like that, or an industry, they will take special permission from the government to buy land. So an association of persons could never buy agricultural land. That's the first aspect. Now, please see the way they have constructed the plaint, my lord. If my lord is pleased to come back to page 35. The plaintiff, my lord, says that I am the son of so-and-so. He never says that he is a partner of the association of persons, though this suit is filed in 23. Now, he describes the first defendant, Daya Associates, as represented by its partner. So either it is an unregistered partnership firm, which then the prohibition under 69 of the Partnership Act will come in. Then he says that the second defendant, that is Akarsh, is also a partner of Daya Associates. Then he says that Dayanandi, who is the sister of the plaintiff, is also the partner. And then he says Muniswamy Reddy are the partners. In this background, my lord, please see paragraph 3 of the plaint. Here he says, the defendant number 1 is an association of persons having a distinct status and existence. The first defendant is recognized under the Income Tax Act as an association of persons and has been allotted a PAN number in favor of the first defendant by the Income Tax Department. The defendant number 1 was constituted on 18/1/2004. And then he goes on to bring the names of the partners. Then please see para 4. The plaintiff submits that the main object of the first defendant is to purchase converted properties, agricultural properties, and develop the properties and sell them to potential buyers. The duration of the first defendant was at will. The bank account of the first defendant was operated by the second, fourth defendant and the said K.M. Prabhakar Reddy. Books of accounts of the first defendant were maintained by its members, partners, and were duly audited by a qualified chartered accountant from time to time. The first defendant has been filing returns under the Income Tax Act and is assessed under the Income Tax Act. Now, this is what is important, my lord. Since the first defendant is an artificial entity, I'm going to demonstrate to my lord that he's been inconsistent in terms of who the first defendant is. So here he says, the first defendant is an artificial entity, cannot own immovable properties in its name. So in the first part, he says that it is constituted to buy properties, The second part is, he says, that it cannot buy properties in its name. Hence, immovable properties and all transactions relating to immovable properties were transacted through the bank accounts of the first defendant by using the funds of first defendant, and all such immovable property were registered and held in the name of the second defendant as a custodian trustee on behalf of the first defendant. Accordingly, all the immovable properties were held by the first defendant as stock in trade of the first defendant. My lord, if it is stock in trade, most respectfully, my lord is pleased to recall his prayer. He cannot ask for a share of a property, because it's like running a restaurant and, if I make it more dramatic, a liquor store, and I say that the stock in trade is all these bottles. I cannot say that I own so many bottles and therefore I should be given. It will say, sell the stock and divide the sale proceeds. Here he says, he himself admits that all the immovable properties are accounted in the books of accounts of the first defendant, reflected in the audited balance sheet of the first defendant as stock in trade from time to time. All the transactions in the immovable properties have been recorded and accounted for in the books and accounts of the first defendant and carried on in the name of the first defendant for and on behalf of the first defendant. Out of the funds belonging to the first defendant, certain immovable properties situated at so and so were purchased in the individual names of one or more members of the first defendant AOP out of the funds of the first defendant. All such immovable properties have been capitalized, recorded, disclosed as an asset in the form of stock of trade of the first defendant.
So according to the petitioner, after the demise of his father, he was inducted into the AOP.
Yes. And he then goes on to dissolve it. So that's what he says in para 5. He talks about one of the partners retiring in 2017. Yes. And then in para 6, in the second sentence, he says, upon the demise of Prabhakar Reddy, discussions were held between legal heirs, so and so.
According to you, under
Yes.
Order 7, Rule A to D,
Yeah.
under which exception, under which provision you will fall?
My lord, one is limitation. The second is, it's a
What is
vexatious.
limitation? What is limitation?
My lord, the property
Hmm.
was purchased by the second defendant undisputedly in 2005. The second defendant has exercised for all intent and purpose in all public records ownership of the property. The land was purchased and under a sale deed.
No, second defendant
Yes.
is, there are.
He sold the property to me.
No. Second defendant.
Yes.
It's not second defendant. It is in the name of first defendant. They
No,
purchased.
there's no sale deed in the name of first defendant.
Hmm.
No property was ever transferred to the first defendant. There is no sale deed in the name of the first defendant. There is no contribution of capital by paying stamp duty and registration charges in favor of the first defendant. Other than the say in this plaint and some unregistered document which the plaintiff canvasses, transfer of title, my lord.
So basing on what he submits that all the properties are acquired
Yes.
on behalf of this first defendant.
Yes. But
Basing
there's
on
no
what
sale
document?
deed. No sale deed. He does not show a single sale deed which shows that any property is registered in the office of the jurisdictional sub-registrar in the name of the first defendant.
What are the documents that are filed along with the plaint?
Yes, my lord. You not brought the list. My lord, he produces the agreement for association of properties, the sale deed, reconstitution
Sale
deed,
deed of whose
in
sale?
the name of the second defendant, not in the name of the first defendant. Not a single title, my lord.
Pass on the.
Yes, my lord. These are the plain documents, huh?
Certain plain documents, not all.
My lord, because there's a bulky plain, but these are the most relevant. Give it to the other side.
Give them a copy.
Yes, yes.
Let's look at this document at page number 7.
Yes, my lord. My lord, I have requested my colleague to just bring one of the sale deeds because there are around 10, 15 sale deeds. But my learned friends will or disagree, the same sale deed. This is the first sale deed made in so and so in favor of Sri S. Akarsh, hereinafter called the purchaser, son of HRS Reddy, hereinafter, which shall mean and include his heirs, legal representatives, and so on and so forth. This is the sale deed. And as I understand, even they do not dispute it. They've extracted it in para 9 of the plaint. Para 9 of the plaint, they have, that's at ink page 41. They've referred to the sale deeds. Para 9 starts at page 40. The plaintiff submits that the first defendant, AOP, purchased the following properties in the name of the second defendant, wherein the second defendant was a mere custodian of the immovable properties for and on behalf of the first defendant, and the same were bought out of the funds of the first defendant, AOP. My lord, if the first defendant...
Page number 4.
Please, my lord.
Page number 4 of that compilation.
Yes. Yes, ma'am. This is the first document of 2004.
Look at it. Page 4.
Yes.
Clause number 6.
6. The bank account on behalf of the association of persons, my lord, please, shall be operated, opened, operated, and closed by the first party, Mr. Akarsh, the first party, the fifth party, Mr. Prabhakar Reddy, and the sixth party, Mr. Muniswamy Reddy. The gains resulted from the operation shall be shared by the members as agreed by them. The association of partners shall be at will. My lord, whatever the internal agreements they have does not convert into transfer of property from a registered sale deed, because transfer of title from one registered owner to another entity can only be by a registered instrument. From 2005 till this suit is filed, there is not a single public document, whether it is he originally bought it as agricultural land, thereafter he converted to non-agricultural purposes, revenue records, mutation, everything stood in his name. Till 2023, when he entered into an agreement to sell it to me, I even issued a public notice. As I recall, there were no objections to the public notice. After that, after a year or so, the plaintiff files a suit, first before a regular court, and thereafter the suit gets withdrawn under Order 7, Rule 10. And then he files it before the commercial court. So there is indirectly, my lord, he is now seeking, if, my lord, if I'm not part of the proceedings and if I'm silent, in effect, only if this property is owned by the association of persons can any of the reliefs of the plaintiffs be granted. If the association of persons is to become the owner of the property, there has to be...
But it's ultimately for him to, during the course of the trial, he'll adduce the evidence.
Well, that is where I'm coming from, a point of vexatious litigation, where a person is now indirectly putting a cloud on a sale deed of 2005. Well, a sale deed of 2005, even if Akarsh in his sale deed has written that I'm executing the sale deed for and on behalf of the association of persons, there's no difficulty. Then I would have purchased a problem. I have purchased a property for a large sum of money in excess of 60.
So that is one ground.
Yes.
Limitation.
Yes, ma'am. Then the second thing, my lord, because of his inconsistent stance, there's no clear cause of action to file the suit, and this is nothing but a vexatious litigation.
Limitation, cause of action.
Yes, ma'am.
Yes.
These are, and by clever drafting, he is now, my lord, seeking for a declaration, because if the commercial court has to grant his relief, it has to first hold that the association of persons is the owner of the property. Now he deliberately does not ask for such a relief, because why he does not ask for such a relief is he will be hit by limitation. But if the commercial court has to grant a partition in his favor, it has to necessarily hold that this property, the possession of this property, the rights of this property is belonging to the association of persons, and this is the unsold stock in trade, and now because he has dissolved it. He doesn't say that. His case is, this is a property which is purchased in the name of Akarsh. Now, my lord, even if Akarsh had taken certain amount of money from the association of persons, then it is for Akarsh to answer to the association of persons. And my lord is pleased to see that normally speaking, the property which will be registered in the name of a person who is not in the immediate family, it is a third person who is the son-in-law. It is not registered in the name of anybody else. He has purchased the property, and the plaintiff has become a member of this association of persons only after his father's death. There's not a single title document which stands in the name of the association of persons. And he himself says that in para 9, he says that this property stands in the name of Akarsh, like I showed to you. Then my lord is pleased to see what he says in para 10, but relevant part is in ink page 44. This is what he says. He says the plaintiff, I'll read from earlier page 43. Thus, all these facts conclusively demonstrate that the first defendant, this is ink page 43, the last line.
Yes.
Thus, all these facts conclusively demonstrate that the first defendant, represented by its members, partners, the plaintiff, the second and third and fourth defendant, is the absolute owner in peaceful possession and enjoyment of the suit scheduled property ever since its purchase. The undivided right, interest, share of each of the members of the partners in suit are held in their respective profit sharing ratio in the said deed of reconstitution of persons dated 29/8/2018, and as stated above, until date, the suit property has been held by all members, partners of the first defendant AOP, that is the plaintiff, the second, third, and fourth defendant jointly in an undivided manner, and the suit property has not been divided or partitioned by the plaintiff and the second, third, and fourth defendant, who are none other than members. Then my lord is pleased to see para 14 at page 46.
Page
46.
Yes.
Para 13, he says about something what the second and third defendant is doing, page para 13. And here he says, para 14, the plaintiff submits that it's under these circumstances, the plaintiff was constrained. Where's the notice? I told you to bring it. The plaintiff was constrained to send a notice of 16/9/23 to the second, third, and fourth defendant and the remaining defendants, notifying that the first defendant is dissolved with effect from 12/9/23, consequent upon the dissolution of the first defendant AOP to effect the partition. My lord, I ask the plaintiff that if, as on 12/9/23, the first defendant was dissolved, then the first defendant could not have been a party to the proceedings because he's already non-existent. And please see, my lord, I'm sorry, I could not produce it along with this extra documents. This is the notice. I may be permitted, my lord, to just pass on. This is the plain document. Give it to us.
Yes.
This is the notice which is given along with the plaint. This is dated 16/9/23. And para 5, my consistent efforts to meet, discuss the second to the fourth of you and resolve the issues, misunderstanding in an amicable manner in the best and mutual interest of all, have yielded no results. Hence, I have no option except to dissolve the first of you and consequent partition division of the immovable property assets physically by metes and bounds by way of this letter, so and so. Thus, I now inform you that Daya Associates, the first of you, is dissolved with effect from 12/9/2023. And in this notice, he says, please see para 2, I'm sorry, please turn back, my lord, to para 2.
Yes.
You are also aware that the first of you is the absolute owner of the following properties. And then next, para 3,
First of you is Daya Associates.
Daya Associates. Now, in his plaint, he says that because Daya Associates is an association of persons and it is not able to own property, therefore it is held property in the name of second defendant. Whereas here he asserts that Daya Associates is the absolute owner. But how Daya Associates has become the absolute owner, it's only according to the Transfer of Property Act. There has to be a registered transfer of title from the second defendant. No such document at all exists. And based on this, my lord, he files a suit seeking to cancel the sale agreements executed in my favor, seeking to ask for a share of a stock in trade. Therefore, if I summarize, my lord, between 2004 and 2017, the land was purchased in the name of second defendant, held by the second defendant. The title was never disputed by anybody, and the second defendant has not executed any document, registered or otherwise, by paying proper stamp duty to transfer the property in the name of the AOP. The AOP never owned the property. By this suit, my lord, he wants to now claim, without seeking a declaration, that the AOP is the owner of the property. Indirectly, he wants to seek a declaration to overcome limitation that the AOP is the owner of the property and therefore there's a partition. Therefore, my lord, I've raised the ground of limitation. My lord, and as he is written in the plaint, that the AOP is not a legal entity, whereas in his notice he says otherwise. So it's not clear what exactly he's saying. Whereas in his cause title he says that this particular AOP has partners. Either they will say it's a member. And my lord, I've also seen many sale deeds where an AOP purchases property. They will say AOP represented by so and so members, and they will register the property.
Yes.
And the AOP has never filed any suit as against them.
Yes. Yes, Ms. Senior Counsel.
All the documents are there, my lord. It's not that, my lord, it has not been filed. My learned friend is now giving, my lord, something, some piecemeal. Every document, my lord, we have produced because he did not produce it. Please come to my lord.
You got it?
Page. Index ಇಲ್ಲ ಅಲ್ಲಿ ನಮ್ಮ AOP ಇರೋದಲ್ಲಿ.
AOP ಇರೋದು first one. Second one.
Second volume, my lord, if your lordship stay. $260.
260 first one. 260 first one.
Sorry, your AOP is where is it? $271, my lord, if you are not first volume, my lord. Sorry.
Yes.
271, my lord, after the death of my father, I became, my lord, the respondent, my lord, who was the petitioner, my lord, plaintiff in the suit, became, my lord, a member of this AOP. Please come to page 272. Mohan Kumar. Now, my lord, what is this? Daya Associates, please permit me read, my lord. Whereas, second unnumbered, my lord, third unnumbered paragraph, last but one paragraph. Whereas first, second and third parties, along with Prabhakar Reddy, my father, Srinivas Reddy and Sridhar, had formed an association of persons in the name and style of Daya Associates, having PAN number so-and-so, under the agreement for formation of the association of persons dated 18/1/2004. That's the first, my lord, agreement where Prabhakar Reddy was, and all these people, my lord, became an association of persons. Said the AOP was formed with the object of purchasing, converting property, etc., etc. My lord, I skip all that. Please come to, my lord. Next page, my lord, 274. Whereas Prabhakar Reddy died on 16/1/2018, leaving behind him his wife, Sushila, his son, Mohan Kumar, the plaintiff, and his daughter, Srimati Dayanidhi, as his only surviving legal heirs. Said Mohan Kumar is a fourth party herein. Whereas, following the demise of Prabhakar Reddy, members of the AOP and the legal heirs of late KM Prabhakar Reddy discussed as to who will step into the place of Prabhakar Reddy so that the business of AOP may be continued. Discussions were held among the legal heirs and the first, second, and third parties in the presence of well-wishers. Whereas Sushila, a wife of late Prabhakar Reddy, expressed that she does not wish to join as the business join the business of AOP. She has released all her right, etc. My lord, given all that. Now, my lord, I'll skip all that. Please come to, my lord, the operative portion at page 275.
Yes.
Para 1. On and from this date of this reconstitution, fourth party shall become a member of the Association of Persons, Daya Associates, formed under this agreement for formation of persons dated 18/1/2004. AOP business will be carried on in the same name. Business of AOP will be the same as at present, carried on and may be changed or added to the present with the consent of all parties. Profit and sharing ratio of AOP shall be borne in this manner. Occurs 20%, my lord, I get, my lord, 38%. Then, my lord, please come to paragraph 9 at page 277. Sorry, my lord, paragraph 8 on the previous page, my lord, 276. Page number. Right. 276, my lord, paragraph 8. Parties have agreed on the audited profits and loss accounts and the balance sheet and have agreed to carry on the business of AOP with the present assets and liabilities from this date. All members of the AOP, including the fourth party, accept and admit audited balance sheet has been signed by them and that the assets and liabilities stand as per the audited balance sheet. Then, my lord, 9, that no party shall accept with the consent in writing of the other members in any way transfer, assign interest, my lord, in the property, in interest or any part in the association of persons to any other party, do or suffer anything to be done whereby association of persons operations may be endangered, assign, change their share in this so and so, so and so, dispose of, dispose of, buy, pledge, encumber, sell, or otherwise part with any part of the assets of the association of order or contract any movable property or immovable property, raise any loan, subject to what is otherwise provided herein, terms and conditions mentioned in the said agreement of formation of persons dated so and so, and, my lord, the reconstitution deed shall be binding on all parties so and so. These properties belong to this son. So, sumni renew idana hakila purti hakila. My lord, sorry, page 273, my lord, this is the most important one. I'm sorry.
I've seen this paragraph number 3, which you were not reading.
Sorry, my apologies, my lord. Because what happened was, this paper book was given to me today. I couldn't mark it. Otherwise, my lord, I mark everything and read
But I've
everything.
seen that they can hold the properties at para number 2. AOPs
Whereas
certain
from out of the
immovable
funds of
properties.
AOP, certain immobile properties in the villages of Sarjapur, Burgunte, Chikka, Dunnasandra, Gunjur, Vartur were purchased in the individual names of one or more members of the AOP. These properties are described more fully in Annexure 1 to this deed and hereinafter referred to as the schedule.
Where is the annexure?
Now, please come to my lord, running page 279. All these are the plain schedule properties. In fact, it used to be purchased, my lord, in different names, and we have produced the sealed deeds. Earlier, there were purchase of in the name of Prabhakar Reddy, some, my lord, in the name of, my lord, the other, the brother, my lord, brother-in-law. And if your lordship sees, my lord, Sarjapur village, Chikka Dunna Sandra village. Next page, my lord, Burgunte, Gunjur, all that. Now, my lord, if you take, my lord, the plain schedule, these are the very properties. So it belongs to, my lord. I'll point out partnership, my lord. If your lordship look at the partnership act, my lord, partnership is, my lord, never an entity by itself. It's a compendious name, my lord, for partners. This is one. Secondly, AOP, my lord, is similar to, my lord, a partnership. That's what, my lord, the Honorable Supreme Court, my lord, I'll give you, lordship, my lord, to judgment, my lord, for my lord's consideration. What has happened is, they purchased, my lord, the lands, my lord, in the name of various, my lord, persons belonging to the AOP. All, my lord, the income tax returns have been filed. If your lordships come to, my lord, volume 3, volume 3, na, volume 2, my lord, sorry. Volume 2, kadi sir. 511.
Shall we continue on Monday?
Yes, my lord. I'm sorry. My apologies. Whenever your lordships want me, my lord, I'll be here. Monday, my lord.
Yes, ma'am.
Please. Oh, sorry, my lord. I also didn't notice. It's already 5:45.
Send it to you.
In junior, it is a train. Index
Madam, list 1.
ಹೇಳಿ ಸರ್.
Madam, list 1.
ಸರ್ ಎಲ್ಲ ಅಡ್ಜನ್ ಆಗುತ್ತೆ ಡೇಟ್.
Madam, list 1 ಯಾವತ್ತಿಗೆ ಅಡ್ಜನ್ ಆಗುತ್ತೆ?
84 ಮೇಡಮ್ ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀರಾ?
ಸೌಂಡೇ ಬರ್ತಾ ಇಲ್ವಲ್ಲಪ್ಪ. ಅವ್ರು ಇದಾದ ತಕ್ಷಣ ಅವರೇ ಮ್ಯೂಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
Next to
Serial number 8.
serial number
8.
ಏನ್ ಬೇಕು ಹೇಳಿ.
Next week ಅಲ್ಲಿ date.
ಅಲ್ಲ ಇವ್ರೆ ಇದು ಅವೈಟಿಂಗ್ ಸರ್ವಿಸ್ ಎಂಟ್ರಿ ಮಾಡ್ರಾಗಿದೆ ಅಲ್ವಾ ಇದು? ಅವೈಟಿಂಗ್ ಸರ್ವಿಸ್ ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತಲ್ಲ 2:30. ಹಾ ಮಾಮೂಲಿ 2:30ನೇ ಅಲ್ವಾ? 2:30 ಮ್ಯಾಟ್ರ್ ಅದು. ಒಂದ್ ನಿಮಿಷ. ಏಟ್ 2/9 ಸರ್ ಅಷ್ಟೇ. ಡೇಟ್ ಇನ್ಯಾವುದು ಅವೈಲಬಿಲಿಟಿ ಇಲ್ಲ ಸರ್. ಇಲ್ಲ ಅದು ಕಾಲ್ ಔಟ್ ಆಗಿ ಏನಾಗಿದೆ? ನೀವು ಮತ್ತೆ ಆಗಿರೋದನ್ನೇ ಕೇಳಬಾರ್ದು. ನಮ್ಗೆ ಟೈಮ್ ಇರಲ್ಲ. 29/8 ಸಾಟರ್ಡೇಗಿದೆ. ಹಾ ಹೇಳಿ ಸರ್. ಹಾ ಆಗುತ್ತೆ ಸರ್. ಅದೆಲ್ಲ ಡೇಟು ಅದೇ ನಾವು ಕೊಡ್ಬೇಕು. ನೀವು ಬೇಕು ಅಂತ ಇಲ್ದಲ್ಲ ಇದ್ರೆ ನಾವು ಕೊಡ್ತೀವಿ. ಆಯ್ತಾಯ್ತು. ಅಟ್ಲೀಸ್ಟ್ ಡೇಟ್ ಒಂದ್ ನಿಮಿಷ. ಹ? ಹೇಳಿ ಸರ್. 27ಕ್ಕಿದೆ. ನಿಮ್ದು ಡೇಟ್ಸ್ ಇರೋದೆಲ್ಲ ಅವತ್ತು ಬರುತ್ತೆ. ಆಯ್ತು. 29/8 ಸಾಟರ್ಡೆ ಕೇಳಿದ್ದಾರೆ. ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಫಾರ್ ಡೆಪಾಸಿಟ್ ಇದೆ, ಅದಕ್ಕೋಸ್ಕರ ಅದು ಬೇರೆ ಡೇಟ್ ಕೂಡ ಸ್ವಲ್ಪ 18/9 18/9